Supplementary list for judgment. Item number 1, SRL 2013.
In view of the foregoing discussions, we are of the view that the prosecution has not only proved that the deceased met with a homicidal death, but also established the circumstances like hand loan of 10,000 taken by the appellant from the deceased for his sister's marriage, not refunding the same to the deceased in spite of repeated demand, the appellant calling the deceased from his house on the date of occurrence and taking him on the pretext of repayment of the loan amount. The last in evidence, appellant returning alone after a short gap when he was last seen with the deceased and his wearing apparels were stained with human blood and he was covering his face with turquoise towel. Nokia mobile set, money purse, and voter identity card of the deceased were from the possession of the appellant. The appellant making extrajudicial confession before the witnesses who detained him while he was returning alone in a suspicious manner. Appellant showing the dead body to the witnesses lying on the hillock in a burnt condition, having caught injury on the throat, leading to discovery of the weapon of offense by the appellant and the injuries noticed on the person of the appellant. The chemical examination report marked as Exhibit 22 indicates that the knife seized at the instance of the appellant from the ashes were stained with blood, human blood. So also his full pant and shirt were also stained with human blood. These circumstances are very clinching in nature, and in our humble view, these circumstances taken together form a complete chain, and there is no escape from the conclusion that it was the appellant alone and none else who was the author of the murder of the deceased. From the circumstances established, it is proved beyond all reasonable doubt that on the date of occurrence, the appellant came to the house of the deceased, took the deceased with him on the pretext of repaying back the loan amount of rupees 10,000 which he had borrowed from the deceased and committed his murder at Konarpur Hillock and tried to dispose of the dead body by burning it in order to cause disappearance of evidence and to screen himself from legal punishment. Therefore, the London Trial Court is quite justified in coming to the conclusion that the prosecution has successfully established the charges under Section 302 by 201 of the IPC against the appellant beyond all reasonable doubt. In the result, the jail criminal appeal being devoid of merit stands dismissed. Before parting with the case, we would like to put on record our appreciation to Mr. Gokulananda Padhi, Land Counsel, for the appellant for rendering his valuable help and assistance towards arriving at the decision above mentioned. This court also appreciates the valuable help and assistance provided by Mr. Aurobindo Mohanty, Land Additional Standing Counsel.
I agree with the view of my brother.
May I be pardoned to mention, my lords? Item 11 and 13 only, not today. So
Supplementary list, item number 2.
My lord, I need pardon to mention item number 14. In this case, yesterday evening, my friend, Mr. Sudarshan Behra, handed over a brief telling that he is
Please wait. Please wait.
So basically, no munda.
Singular.
Reduce the premature release the report of the appellant at flag Y. Yes, next.
Item 3.
Single appellant. Kanguru
and good dick.
Diggy.
Another appeal was filed, my lord. The same postform.
Please wait. Kanguru Diggy. Acha. You know, so the disposal. Same, the detailed appeal, disposal. Heat appeal file to discuss.
The withdrawal ପାଇଁ ଦେଇଛନ୍ତି ସତଟା ଦେଇଛନ୍ତି।
Or outright.
अच्छा ये तो withdraw
এটা withdraw।
तो withdraw कर दियो 7 का disposal करो है ना।
Item 4.
Non-compliance to orders plus 7/8/2024 by Daniel Suvan. What was the direction? The direction is to consider the reference from the petition by Daniel Suvan. 3 months from the date of communication of the, when you communicated the order.
Annexed to running page 13, Lordship.
No, have you, where is your averment?
Lordship. I also annexed the acknowledgement with regards to the postal district. Lordship.
Communication was made on
12/9/2023.
Para 3.
Acha, 12/9/2024. Yes. But you have mentioned that communication letter is dated 6/8/23. The order was passed on 7/8/24.
Yes, sir.
So obviously.
How could it be on 6/8?
Communication letter ta kaun annex 2 you go.
Yes. The annex of wrong.
Era bar no ko.
I have reflected, but when the copy of the communication is wrongfully.
That communication date has been wrongly mentioned. It should be 12/9/24.
Yes, yes.
You take instruction, who is to carry out the order? To the Richmond. Mr. Naik,
My lord.
take instruction whether the representation has been disposed of or not. This contempt petition has been filed by the petitioner so and so. For non-compliance of the order dated so and so. The petition was disposed of by the order dated 7/8/2024. And the operating part of the order reads like this. For the nature of the liquid, for the merits of the representation. Specific averment has been taken in the contempt petition in paragraph number 3 that the order passed in the writ petition dated 7/8/2024 was communicated by the petitioner to the Chief Secretary, General Administration Department, Orissa on 12/9/2024, and the communication letter has been annexed to the contempt petition as annex of the stock. The AD has also been the receipt, the postal receipt has also been annexed stock. The land councils of the state took some time to obtain instruction relating to the status of representation. Allah, put up this matter. What is up for an
Obviously.
22 तारीख of the sorry, 23 तारीख 23/9/2025. Yeah.
Item 5.
To dates for instruction, we are in non-compliance of the order district 24/9. That case may not be restrict the instruction, but that part is not been completed because they are only demarked the land, whether that disburse the amount, that part has been
What
mentioned.
was our order?
That order was that
In view of the above, we dispose of the writ petition for a direction with a direction to the opposite party, more particularly to opposite parties number 4 and 5. Tahsildar and
body.
executive engineer. to disburse the specific direction of
That
to
has not
disburse the
been done.
compensation amount as expeditiously as possible and so on and so on.
There only the demarc the land. I pay more times.
Because it was already quantified.
Yes, they have annexed.
It's all right. Let him obtain the instruction. The Learned Counsel for the state, who has obtained some instruction in the light of the order dated 21/8/2025 from the Tahsildar Bari, but he seeks some further time to obtain specific instruction as to whether the compensation amount has been disbursed to the petitioner as per the order dated 24/9/2024 or not. The written instruction, the letter dated 4/9/2025 of the Tahsildar Bari is taken on record, put up this matter on 23 CR.
Item 6.
That's it, Lordship. The file an IA for stay of realization of fine.
Yes, sir.
Your Lordship, the appellants are on bail. Meanwhile, appellant number 1 has already passed away, Lordship.
That is the since long.
No. Why this matter has come?
Your Lordship, for stay of
Possibly.
realization of.
Stay of file. Oh, stay relation of fine.
Yes, your Lordship.
2416.
Yes, your Lordship.
अच्छा
Not
यही
the-
नथिला स्टे रिलेशन ऑफ फाइन यही नथिला
No, your Lordship. This is a transfer case, your Lordship. The
it's
council.
all right but no, bail you have been granted but not the stay.
Yes, your Lordship.
फाइल करथिले ना नहीं माने फाइल करनथिले भूल रे रही
Your Lordship, file ही नथिला. से पूर्व
अच्छा
पूर्व काउंसिल जे थे से मिस्टेक रे ओमिट कर लेते फाइल में.
फाइल करना थी खाली बेल दरखास्त फाइल करछन से जणा तो IA number 2416 of 2025 is an application for stay of violation of the service stay of violation of fine in the disposal of the criminal appeal. Yes. IA disposal for the
Item 7.
May I please announce? Under modification of my lord's order,
but
order dated 11/8/2025.
on
Para 6 court nata towards Fairlight. Set our learned district and session judge Jharsuguda in ST case number ta bhi padi. 16 of 30.
court na ठीक अछि
Court nata learned district and session judge Jharsuguda.
Yes, that's a civil, but
Case number ta padi. ST case number
case number
16.
Acha. This is an application for modification of the order dated such and such. The land council for the petitioner, Mr. Das submits that inadvertently the sessions trial number has not been reflected in the bail order. And this may kindly be reflected. Land council for the state, hardly land council for both the parties. It is made clear that the order dated 11/8/2025 in IN number 2123 of 2025 has been passed in connection with ST case number 16 of 2023.
Net 2013 matter.
Sorry, ST case number 16 of 2013 in the court of Learned Session Judge Jharsuguda.
Matter.
Yes, next.
Obliged.
Item 8.
Lordship, on paragraph 3 of your Lordship judgment, your Lordship order dated 25/8/2025,
order
25/8/2025.
yeah.
In paragraph 3, your Lordship.
Uh,
It will be criminal trial number 5/2015
no.
and learned additional session judge Koraput.
If you see in my
double check IA number so and so, there is an application for modification of the order dated 25/8/2025. Land Council for the appellant Sunita Biswal submits that in paragraph 3 of the order, the court name as well as the case number has been incorrectly requested. Land Council for the state also accepts the submission made by Land Council for the appellant. Accordingly, in paragraph number 3, the sessions case number shall be read as CP case number 5 of 2015 in place of sessions case number 11 of 2008 and the name of the court shall be read as additional session judge Koraput in place of additional session judge Muamara. Bracket the rest part of the order remains on order. IA disposed of. Yes.
With your Lordship permission, a small prayer. Let them be directed to produce this certified copy of this order thereafter before the learned court below, and thereafter they will furnish the bail bond.
No, you are to produce the earlier order, so also this
Your
order.
Lordship, I will produce.
Earlier order you must have received.
Your Lordship.
Now this order you will get it today and file the bail bond tomorrow. There is no problem. Yes. This order will be also uploaded today.
Yes.
Yes.
That,
Next, item number 9.
Item 9.
Yes, Mr. Jena, what modification? Sorry.
Modify the order
to approve the learning additional assistant commissioner endowment. Order.
The Commissioner of Endowment shall take a decision after giving opportunity of hearing. That was also that number. And you could have given it.
Because you get a commissioner of
Assistant endowment.
That's also take admin.
The Commissioner endowment and
Cooperating and together.
Assistant endowment.
IN number 14788 of 2025. This application has been filed for modification of the order dated 37/2024 and directing the petitioners to approve the additional assistant commissioner of endowment chartered under section 41 of the Orissa Hindu Religious Endowment Act. The Land Council for the petitioners submitted that in the order dated 37/2024, it has been directed that whether this 41 में तार power है to decide करे वो देखिए ये after
That's it.
41 of the Orissa Hindu Religious Endowment Act.
Whether it is private or public.
Chhattisgarh power. Ordinarily, copy should have been given to his name. नहीं endowment office. Local. वो पासओवर कर दो कि तब मगे किन तो लाइब्रेरी में थोड़ा डाल दो लाइब्रेरी खबर दियो पटे whether institution is public or religious.
That is the foremost author.
अच्छी power है कौन कौन लिख लो the whether the deity is a private deity or not is to be determined by Commissioner of Endowment, and therefore the petitioner was given liberty to approach the Commissioner of Endowment by raising the grievance. And the Commissioner of Endowment was also directed to take a decision after giving opportunities to all the parties concerned and after verifying all the documents. It is stated that under section 41 of the sworn soul, the additional assistant commissioner of endowment has jurisdiction to decide the issue involved and in case the matter is decided by the Commissioner of Endowments, also the petitioner would do appellate forum. considering the amendments taken in the interim application, we modify the order dated 30/7/2024, directing that the petitioner shall approach the additional assistant commissioner of endowment under section 41 of the Orissa Hindu Religious Endowment Act. And who will decide whether the deity in question is a private deity or not. The additional swans shall take a decision after giving opportunity of hearing to all the participants and after verifying all the documents. The rest part of the order remains on order. Yes.
Item 10.
Item 10, may I please, Your Lordship. Your Lordship, I'm alleging the non-compliance of the order dated 18/9/2024, Your Lordship.
Yes.
Connected matters are posted to Solana. All the matters are connected posted to Solana. ଏଥିରେ କ'ଣ ଯେ ଯୋଉ କଣ୍ଟେନର କରିଛନ୍ତି ଶ୍ରୀମତୀ ଏକତା କୁମାରୀ ସେମିତି କାହିଁ GM post NHA ରେ ନାହାନ୍ତି. However, NHA directed the PD Sambalpur to appear and take proper steps in the matter. Accordingly, I have entered my appearance. I pray Your Lordship call this matter on 16th.
Connected matter 16
ଆଜ୍ଞା ସବୁ ଯାକ ଅଛି.
Acha, Mr. Mahanti Land Council appearing for the container submits that connected matters are posted to 16/9/2025, and this matter may be taken up on that day.
Okay.
Salabana General Land Council is present to virtual mode put up this matter on 16/9/2025. Yes.
Okay.
Bless you, Lordship.
You have to verify it, you hearing the list is order number so and so DSP Ganjam. देखिए ये कितने में आप प्लान रचना तू आगे बोलते हो in the appeal method
ଅଛନ୍ତି
CRA ପାଞ୍ଚ ଜଣ
The appeal now survives only for appellant number 1, namely Ramaya Sethi, appellant number 3, namely Kamaraju Lingam, and appellant number 4.
My lord has directed me to
Narayan Ghadi did.
yes, Narayan Ghadi did, and
Also
Kumar Naik.
That is number 5. So A1, A3, and A4.
They are alike.
They are all.
They have mentioned it. So, I'm ordered that to be sacked for this.
Two and five. Yes, 2 and 5. Yes. What Mr. Which item you are telling?
I will do this item tomorrow because today I have been little blood pressure has increased. So that is why I have not gone. Tomorrow I will do it.
No, tomorrow, it's a day after tomorrow, Mr. Das. We are just keeping it. It will be not going out of the list.
No. Tomorrow even I am ready, but today I am not feeling
What
little.
about this with the connected matter?
Connected matter, it is, I have filed.
Both are.
Kailas Ghadi.
There is only one accused, Kailas Ghade, he is alive.
Vanchiji na?
Aage bachich, se bachich.
Acha.
Mo instruction nahi se bachich.
Acha. Tapare, apunar keto.
Well, item number 14, I am appearing at the request of Mr. Sudarshan Behera with Bhakla's Nama, and I pray if a copy of
Item number 15.
14.
14 रे अच्छा
Non
प्रशांत
appear.
कुमार
Sahu.
साहू अच्छा report of whereabouts received at Clark C may kindly be perused.
The original advocate died. It was
Just Apparent Prashant Kumar Sahu was in the house. Vanchiji Rauchi single appellant. हाँ ठीक है.
मत खाली टीसीआर गोटे कॉपी देदेले मु असिस्ट करबी नेक्स्ट लिस्ट रे मु आसदा विकेट करबी
TCR ना पेपर
पढ़ी
बुक
पेपर बुक
पेपर बुक बात देई जति तो टीसीआर कपटा तबे वेरीफाई करियर अछि बेडे टिकट से डिजिटल कॉपी पेन ड्राइव रे मु नै
सबू तादेरे
सब
केवल
ଅଛି।
आपण जदी कहबे एग्जिबिट टा देई हबो
Exhibit.
हां एग्जिबिटेड है सेबडा
एग्जिबिट दे बाकी तो सब तो पेपर बुक रे अछि
हां सेटा केवल नाही मु देखतली रात रे टिके
Exhibit टा रोहनी
बेडे टिकट कर टू प्लस अपीयरेंस
पेपर बुक तो अछि त आपण
हां पेपर बुक देइछन मते नै थर देइछन
सील रिपोर्ट टा को बोलुछि
ये रिपोर्ट
और
स्पॉट में
जो एफआईआर टा स्पॉट ला भेति
चार यूनिट
और
और रियल एग्जिबिट टा
कौन टा कर
ये जो
हां करो दे
पता है
पेपर बुक टा भरला दे आदि
Good like it.
ये टा ना
हां मैं बोल को पेपर बुक क्या बोल
कंटेंट्स में
हां जजमेंट का सुन ठीक है आपण बा पेपर बुक
हाँ, ठीक अछि।
पढुना दी जजमेंट का सुन पेज 14 रे
मैलर
प्लीज रीड दी जजमेंट
लास्ट पैराग्राफ ओनली
लास्ट पारा नहीं पूरा प्रथम एक नंबर पारा आरंभ
Oh, yes. The above named accused charged on section 302 and 201, read with section 34 of IPC for having committed the murder of John.
पूरा
Oh, sorry, it is connected acquittal. The who accused and in another
क्रिमिनल
Appeal
अपील नंबर 229 ऑफ 2000 रा पेपर बुक बाहर करंतु तादेरे ट्रायल कोर्ट रो जजमेंट अछि पेज
Page
नंबर
14
14 रे
हाँ ट्रायल कोर्ट जजमेंट अच्छी
हां सेटा गुटे पढंतु आपण पेपर बुक काई
देले मु तो पढ़ुतली जाको अलका पते रहि गला मु पढ़ुतली अलका रहि गला जजमेंट खाली ताकर अछि
पेटु पढम
The accused stands charged on section 302 and 201, read with section 34 IPC. The long and short of the prosecution case is this: the deceased couple Jadu Sahu 75 and Ittei Sahu 65 were issueless. Accused is the son of the sister of deceased Petal. Ittei on one
जस्ट अ मिनिट जस्ट टिके स्लो रे जीवन फैक्ट टिके भलो जिन बुझि देला कुछ
मु बुद्धि छटा पढ़ी जिबु केना से
अरे आपण पढ
ओ एठी हां
हां
The deceased couple Jadu Sahu 75. Jadu Sahu and Ittei Sahu 65 were issueless. Accused is the son of the sister of deceased Ittei. On 1/2/1993, the deceased couple adopted the accused as son and executed and registered a deed of adoption, Exhibit 13. Whereafter, the accused, along with his first wife, Vijay Lakshmi Sahu, resided with them in their house at Bakshara. Sometimes thereafter, the accused accepted his first wife and married another lady, namely Shantilata, and brought her to the house of the deceased couple at the teeth of their opposition, showing the seeds of discord. There was also bickering amongst them as the accused was insisting for recording the properties of the adoptive father, Mrs. Jodusau, in his favor. In the night of 13-14-8-1996, which incidentally was this night of Chittalagi Amavasya, the accused and his second wife, Santilata, attacked the deceased couple, adoptive
Parents.
parents in their bedroom, killing Jadu intentionally and critically injuring Pitei, who lost consciousness at 6:10 a.m. on 14-8-1996. The accused lodged written FIR, Exhibit 14, at Jodhpur Police Station, stating therein that deceased Jadu and deceased Pitei were a squabbling couple and often used to assault each other in course of quarrels, and at 8:30 p.m. in the night of occurrence, they had a round of quarrels over preparation of cakes to celebrate Chittalagi Amavasya, in course of which they had sworn to kill each other, and in the next morning at about 4:30 a.m. he accused found deceased Jodu laying dead in the floor of the bedroom with bleeding injuries, while deceased Pittai was laying unconscious by his side and was bleeding from the head and mouth. Whereupon Jotni Police Station, case number 150 dated 14-8-1996 under 302 IPC, GR case number 2307 of 1996 was registered, arraigned deceased Pittai as accused. Deceased Pittai succumbed to the injuries at 4:30 a.m. on 15-8-1998 while receiving treatment at the Jotni PSC. As the investigation progressed, the complicity of the accused and his wife Santilata in the crime came to the surface, for which the IO PW13 reported Jotni Police Station, case number 150, dated 14-8-1996, GR case number 2307 of 1998, registered against deceased Pittai as false and lodged FIR, Exhibit 17, against the accused and Santilata were on 48 rupees. Jotni Police Station, case number 25 dated 5-1997 was registered. In due course, the police submitted a charge sheet against the accused and his wife Santilata on section 302 and 201, read with section 34 IPC, showing the accused as an absconder. As the accused absconded, Santilata, along with alone, charged on section 302 and 201, read with section 34 IPC, ST case number 145 of 1997, and my predecessor, who was in session of the matter by her judgment dated 18-1-99, recorded as acquittal. Recorded on acquittal. In marked departure from the story put forth, the FIR Exhibit 14 that accused during his examination, 313 CRPC, took the plea that prior to his adoption, deceased Jadu had first adopted his accused elder brother, Prasad, who was murdered in the year 1978, and the persons who murdered Prasad have murdered Jadu and Pittai. No defense has been adduced. Dr. Bimal Kumar Rath, PW4, gynecology specialist, Sub-Divisional Hospital, Khurda, who conducted autopsy over the dead body of deceased Jadu at 3 p.m. on 14-8-1990, found the following external injuries. 1. Lacerated injury on left forehead of size 1 inch into 1 inch into 1 inch into half inch with extravasation of blood into the both eyelids, which over the right side of the chest of 5 into 3 inch, 5 into 3 inch size. On dissection, he found the following internal injuries. Corresponding to external injury number 1, there was extra passation of blood into the tissue spaces without any fracture of underlying bones. Corresponding to external injury number 2, there was fracture of second to ninth rib underlying external injury number 2 and hemorrhage into the space. Pleural cavity was full of blood with laceration of pleura. Underlying external injury number 2 and right lung looked pale. Left lung and pleura were intact and looked pale. 4. Ventricles were empty. Liver and lacerated and abdominal cavity was filled with blood. In the opinion, all the injuries were antemortem in nature and were sufficient to cause death in ordinary course of nature. The death was due to hemorrhage and shock resulting from the aforesaid injuries. Dr. Abhay Kumar Patra, PW7, pediatric specialist, District Headquarters Hospital, Khurda, who conducted autopsy over the dead body of deceased P.T. Sahoo at 1:15 p.m. on 15/8/1996, found the following external injuries. Black eye right side, abrasion and lateral angle of right eye with hematoma on the right temporal region, fracture of right mandible and lower jaw, medical 5 teeth with mandible separated from lateral part. Heavy blood stains and clots were present. On dissection, he found the following internal injuries. Fracture of right side ribs from second to fifth rib with lacerated injury to right lung lateral aspects, and there was heavy collection of blood in thoracic cavity. In the opinion, all the injuries were antemortem in nature and were sufficient to, in ordinary course of nature, to cause death, and the death was caused by shock and hemorrhage due to injury to the vital part like lungs, and also the homicidal deaths of both the deceased. Jaddu and his wife, deceased Pitei, is born out of medical evidence. It is not disputed by the defense either. Remains to be examined. Whether the accused is the author of the death of deceased Jaddu and deceased Pitei, and whether he has intentionally caused their death. The PW 119 are the neighbors of the deceased couple. The PW 2 and 9 have turned hostile. The PW 1 has testified that the accused is the son of the sister of deceased Pitei. As the deceased couple were issueless, they adopted the accused as son, and the accused, along with his first wife, lived with them happily in one mess. The trouble began when the accused disowned his first wife and married Antilota and brought her home against the wishes of the deceased couple, for which he accused, along with Antilota, lived in separate mess. leading to strained relationship with the deceased couple. He, PW1,
Came to
came to know about the incident in the early morning of 14/8/1996 and went to the house of the deceased couple and found deceased Jadu laying dead and deceased Pitei laying unconscious with massive injuries over their body. He has witnessed the inquest made over the dead body of the deceased Jadu and the police at 7:30 p.m. on the very day. The PW2, another neighbor of the deceased couple, has stated that she too learned about the incident in the
we have
in the
we
was
have in the we have our
in the hours of 14/8/1998 and went to the house of the deceased couple at 4:30 a.m. and found deceased Jadu laying dead and his wife deceased Pitei laying unconscious, and both of them had sustained bleeding injuries. The accused and his second wife Santilata were present in the house, and on being asked how the deceased Jadu died, the accused pleaded ignorance.
ignorance.
The PW2 is also a witness to the inquest held over the dead body
Of
of the deceased
Jadu.
Jadu by the IO PW14. The
Level 9.
PW9, another member of the deceased couple, has testified that in the night of occurrence at about 8:30 p.m., deceased Jadu went to his house, inquired about his father, and informed him that there was a quarrel between him and his wife, Pitei. He, PW9, went along with him to his house and dissuaded
Him.
him and Pitei from quarreling. PW12, the junior clerk cum record keeper of the officer of the sub-registered attorney, has produced the book number 4, volume number 1 of year 1993, containing entries in respect of deed at number 7, dated 1/2/1993 at pages 45 and 42-48, Exhibit 13, evidencing execution and registration of the deed of adoption by the deceased couple in favor of the accused. PW10, the brother of the first wife of the deceased has deposed that the marriage of the accused with the sister Vijayalakshmi Sahoo was solemnized in the month of January 1989, and they begot a daughter out of the wedlock. But 5 to 6 years after the same, the accused again married another woman named Santilata and lived with the deceased Jadu and Pitei along with Santilata. PW 13, the IIC Jotni police station reports that at 6:10 a.m. on 14/8/1990, the accused filed a written report, Exhibit 14, intimating that in the last hour of the morning, he found his adoptive father Jadu laying dead and his adoptive mother Pitei found unconscious in the floor of the bedroom.
Both of them.
In course of a quarrel in the previous night, threatened to kill each other. Whereupon, Jotni PS case number 150 of 1990 was registered, and SI T. Harikrishna Murthy, PW 14, was directed to take off investigation. The PW 14 has testified that he visited the house of the deceased couple on 14/8/1996 and found deceased Jadu laying dead on the floor of the bedroom with bleeding injuries, and his wife deceased Pitei laying by his side in a pool of blood in a critical condition, and a blood-stained Khanti MO1 was also laying on the floor. He sent injured Pitei to the railway hospital, Jotni, with requisition Exhibit 28 through Constable number 317 T. Pradhan for treatment, and held inquest over the dead body of deceased Jadu. Whereafter, he sent the dead body of deceased Jadu to the SDMO Khurda for postmortem examination. Through Constable PW11 on requisition, this scientific officer collected blood of deceased Jadu laying on the floor by soaking it with thread and made over the sample blood thread and thread to him PW14. The PW14 seized the
Sample blood.
Throat MO5 and control thread MO6 collected by scientific officer under the seizure list exhibit 29 and the Conti MO1 laying on the floor of bedroom under the seizure list exhibit 2 and prepared the spot map exhibit 22. On receipt of the information from the medical officer Jotni PSC that Pitei succumbed to the injuries at 4:30 am on 15/8/1996 while receiving treatment in Jotni PSC from Sondapur, the PW14 held inquest over the dead body and sent the dead body to the STMO Khurda for postmortem examination through Constable number 747 and 237. The accused in his statement on Section 13 CRPC has admitted that he is the natural son of the sister of deceased Pitei and deceased Jadu, and Pitei had adopted him as son by executing and registering an adoption deed exhibit 13, and after the adoption was residing with the deceased couple in their house along with his second wife Santilata, and in the fateful night be along with Santilata were present in the house. He has further explained in his statement under the 13th CRPC that in the morning of 14/8/1996, he accused along with his second wife Santilata found deceased Jadu laying dead with bleeding injuries in the bedroom, while deceased Pitei was laying unconscious with bleeding injuries in the same bedroom, and lodged the FIR exhibit 14 at 6:10 am on 14/8/1996 at the Jotni police station.
Judgment আপনি better দেখা হচ্ছে।
এটা ভালো কথা সেটা কি অরিজিনালটাতে কাগজটা মরে গেছে
Page 10.
ওহো On receipt of information from medical officer Jotni PSC that Pitei succumbed to the injury at 4:30 am on 15/8/1996 while receiving treatment at in Jotni PSC Sondapur, the PW14 held inquest over the dead body and sent the dead body to the SDMO Khurda for a postmortem examination through Constable number 747 and 237/11. The accused in his statement on Section 13 CRPC has admitted that he is the natural son of the sister of deceased Pitei and deceased Jadu, and Pitei had adopted him as son by executing and registering an adoption deed exhibit 13, and after the adoption was residing with the deceased couple in their house along with his second wife Santilata, and in the fateful night of he along with Santilata were present in the house. He has further explained in his statement on 13 CRPC that in the morning of 14/8/1996 he accused along with his second wife Santilata found deceased Jadu laying dead with bleeding injuries in the bedroom, while deceased Pitei was laying unconscious with bleeding injuries in the same bedroom, and he lodged the FIR exhibit 14 at 6:10 am on 14/8/1996 at Jotni police station, stating therein that in the night of occurrence there was a quarrel between deceased Jadu and his deceased wife Pitei over observance of Chittararanjan by preparing cakes for which they had threatened to kill each other. The rough sketch map exhibit 22 of the house of the deceased couple prepared by the IO PW13 reveals that the house is of square size and faces to the south. There are 3 rooms in front side facing to the south, whereas 3 rooms are situated in the rear room being intervened by a courtyard with a well. The kitchen room is situated in the eastern corner of the courtyard after the inner veranda of the rear row of rooms. There is a side veranda to the west, having on the entrance door to the backyard. The staircase is situated at the corner where the side veranda joins the inner veranda attached to the front row of the rooms of the three front rooms. The room number 1, as shown in the map, is the entrance room having the entrance door leading to the outer veranda. The room number 2 is used as a store, whereas room number 3 is the bedroom of the deceased couple of the three rear rooms. Room number 11 and 12 are used as storerooms, and room number 10 is the store cum bedroom of the accused and his wife, Santilata. From the spot map, Exhibit 22, it appears that the bedroom of the deceased couple is not accessible from outside unless the front or back door are kept open. This apart, the occurrence took place in the rainy season in the month of August when nobody sleeps in the night, keeping the door of the bedroom open. The IO Pedal 14 has denied the defense suggestion that the staircase is situated adjacent to the room of the deceased. The PW9 who was returned hostile, has stated during prosecution that the house of the deceased couple consists of 6 rooms, out of which 3 are pakka and rest 3 have asbestos roof. The deceased couple were residing in the pakka rooms, whereas the accused and his second wife, Santilata, were residing in the asbestos rooms, which, through situated at a distance of 10 feet, are interconnected. Thus, nothing has been brought out either from the IO or any of the prosecution witness that the bedroom of the accused deceased couple is accessible from outside without using the front and side doors. The following facts are both proved and admitted. The accused, the adopted son of the deceased couple, and was residing with them along with second wife Santilata. The accused and his second wife Santilata were present in the house in the fateful night. No other person other than the deceased couple and the accused and his second wife Santilata were present in the house in the fateful night. 4. The accused has lodged FIR Exhibit 14 at 6:10 a.m. on 14/8/1996 alleging therein that in the night of 13/8/1996 at 8:30 p.m. there was a quarrel between the deceased Jadu and his deceased wife Pitai over preparation of cakes for celebrating Chintalagya, in course of which they threatened to kill each other. The FIR plea of the accused of possibility of a fight between both the deceased, inflicting fatal injury to each other, does not bear scrutiny, in as much as deceased Jadu and deceased Pitai were about 75 and 65 years respectively, as per the postmortem examination report Exhibit 4 and 9. The IO Pedal 14 found a Khanati MO1 in the bedroom of the deceased couple having 3 feet 6 inch long bamboo handle fitted with a 6 inch long iron blade at the top of or side having stains of blood. The doctor Pedal 4 who conducted autopsy over the dead body of the deceased Jadu opined that only the external injury number 1, lacerated injury, is possible by the MO1. The Dr. Pedal 7 who conducted autopsy over the dead body of Pitai has stated in para 6 of his deposition that the IO has produced MO1 before him with the query whether the injuries noticed on the dead body of Pitai are possible by MO1, and on examination of the MO1, he opined by Exhibit 10/1 that injuries noticed on deceased Pitai are unlikely to cause by the MO1. The London Public Prosecutor declared Dr. P7 hostile on this point and put leading questions, in course of which P7 has stated that the injuries noticed on deceased Pitai are possible by the handle of the MO1. The MO1 was sent for chemical examination. The chemical examination report Exhibit 16 reveals that two small blood stains was detected on it, which was insufficient for serological test. Both the doctors conducting autopsy have opined that at best the handle of the Khanati MO1 would have been used to inflict the external injury number 1 on deceased Jadu and the injuries on deceased Pitai. The opinion of the doctors therefore rules out the use of the iron blade of the Khanti MO1 in inflicting injuries on either of the deceased, as no inside wound was detected on any one of them. I therefore discard the MO1 as the weapon of offense. It does not stand to reason that the old couple like Rishi Jodhu and Pitei will quarrel over a trivial and flipping matter like preparation of cake for celebrating Chittanagi Amavasya. The PW1 has categorically stated that there was cordial relationship between Rishi Jodhu and Pitei. Nothing has been elicited during cross-examination to impeach the veracity of the PW1. Of course, the PW9 has stated that in the night of occurrence at 8:30 p.m., Rishi Jodhu went to his house and informed him that there was a quarrel between him and his wife, Rishi Pitei, and the PW9 went to the house of the deceased Jodhu and pacified the deceased couple. The PW9, as per his version, is now aged about 25 years. It does not stand to reason that a 75-year-old man will go to a youth of 25 years of the village, ignoring the elderly neighbors, to request for good offices to act as peacemaker between him and his deceased wife. This apart, the PW9 was believed the prosecution was confronted with his previous statement made before the IO on section 161 CRPC, wherein he has stated that there was a quarrel between the accused and deceased Jodhu on the fateful day, that is 13/8/1996, for which deceased Jodhu had called him to his house at 8:30 p.m. and he has dissuaded the accused and the deceased Jodhu from quarreling. Though the PW9 has denied to have made such a statement before the IO PW13 has confirmed in para 16 of its deposition that the PW9 has made the statement before him. This is a glaring contradiction in the evidence of the PW9, which cast doubt on its veracity. I therefore accept the evidence of the PW1 that Rishi Jodhu and Pitei were a happy couple having cordial relationship, and the story of a quarrel between them over a trifling matter like preparation of cake, for which they fought against themselves by the same Khanti MO1, which has been discarded as weapon of offense, crumbled down like a house cards. Now, exploring possibility of outside intervention in that fateful night, I find that IOs PW 13 and 14 have not whispered a word if they have noticed any mark of violence on the entrance door, back door, and the door of the bedroom of the deceased couple. In a case of outside intervention, the crime cannot be accomplished by the single miscreant, and as such, involvement of more than one person would be there. The crime of such a magnitude, in which an old couple sleeping in their bedroom in a well-protected house with the entrance door, back door, and door of the bedroom closed, cannot be done without violence to the house, causing enough noise and commotion to awaken the accused and his wife from their deep van winkle sleep. During the examination of under section 13 CRPC, the accused changed his earlier plea of both the deceased, swearing to kill each other in course of a quarrel before going to bed, to one of the outside intervention of by stating that deceased Jodhu had earlier adopted his elder brother Prabhat Sahu, who was murdered, and the persons who had murdered him, Prabhat, have also murdered the deceased couple. But he has not spelled out who are the persons who had murdered his brother, Prabhat, and how they are connected in the murder of the deceased couple. He has also failed to explain why, at the earliest opportunity, she took the plea in the FIR Exhibit 14 that the deceased couple had a quarrel before going to bed in that fateful night, in course of which they had sworn to kill each other. I therefore hold that there was no outside intervention. It is both proved and admitted that besides the deceased couple, the accused and his second wife, Santilata, were inside the house in that fateful night. The deceased couple were sleeping in room number 3 as per the spot map 22 of the front row of the rooms of the building, while the accused and his second wife were in occupation of the room number 10 of the spot map 22 at the rear row of the rooms. The earlier plea of the accused that the deceased couple fought themselves inflicting fatal injury, and the latter plea of the accused there was outside intervention having been ruled out. The only irresistible conclusion is that the accused has inflicted fatal injuries on the deceased couple, killing deceased Jadu instantaneously and injuring deceased Pitai critically, who has found in a comatose stage. There is also another bizarre aspect of the crime. The IO, period 14, had sent injured Pitai to the railway hospital Jotni with requisition Exhibit 28 for treatment and examination. But the medical officer of the railway hospital Jotni has not been cited as a charge sheet witness, though he had issued injury report overly the requisition wherein he has endorsed that the patient was referred to the SCB Medical College Hospital, Cuttack, but surprisingly, deceased Pitai was shifted from railway hospital to Jotni PSC at Sondapur. Still more surprising is the evidence of the second IO, period 13, that in spite of the direction to shift deceased Pitai from Jotni Hospital to Capital Hospital, Bhubaneswar, the ambulance driver took the deceased Pitai to Jotni PSC at Sondapur. The medical officer Jotni PSC, February 15, has reported that at about 3:40 p.m. on 14/8/1996, deceased Pitai was admitted to the PSC, and at 3:45 p.m. he referred her to the SCB Medical College Hospital, Cuttack, as her condition was critical, but the treatment attendant of the patient did not shift her to the SCB Medical College Hospital, Cuttack, and the accused that the persons who had murdered him, his brother Prabhat, have murdered the deceased couple has been discarded as per reasons given in paragraph 16 supra. It says 3 पेज नहीं इतनी 18 पर 19 20 नहीं 18 पेज पर 19 20 टा नहीं This is Pitai succumbed to the injuries while taking treatment in Jotni PSC at 4:30 a.m. on 15/8/1990s. It therefore appears that the accused intentionally failed to shift this Pitai, who is no other than his adoptive mother, from Railway Hospital Jotni to the SCB Medical College Hospital, Cuttack, and again from Jotni PSC to the SCB Medical College Hospital, Cuttack. This conduct of the accused is incompatible with the anxiety of a son to save the life of his mother. The prosecution has not spelled out the motive of the accused in so many words, but the PW1 has categorically stated that the relationship between the deceased couple and the accused became strained as he deserted his first wife and brought home the second wife Santilata at the teeth of their opposition. No doubt, the PW9 in para 5 of its cross-examination has stated that there was no ill feeling between the adoptive parents and the accused and his second wife, but his statement before the IO was otherwise, which has been discussed at length in paragraph 15 supra. I therefore accept the version of the PW1 that there was strained relationship between the deceased couple and the accused and his second wife Santilata, and doing away with the adoptive parents is a shortcut path to get immediate access to their properties. The essential ingredients to prove the guilty of the accused, where there is no direct evidence that one, the circumstances from which the conclusion is drawn should be fully proved. The circumstances should be conclusive in nature. All the facts so established should be consistent only with hypothesis of guilty and innocence of the accused. The circumstances should be proved to a moral certainty exclude the possibility of the guilty of any person other than the accused. Please see in the case of State of UP versus Dr. Ravindra Prakash Mittal, JT 1992 to SC 114. The following circumstances point unerringly the conclusion that the murder of the deceased couple was committed by the accused. The deceased couple and the accused and his second wife Santalata were the four persons present in the house in the fateful night. The earlier plea of the accused, as stated in the FIR Exhibit 14, that the deceased couple fought and inflicted fatal injuries on each other has not been substantiated as per the reasons stated in paragraph 14 and 15 Supra. The second inconsistent plea of the accused that the persons who had murdered his brother Prabhat have murdered the deceased couple has been discarded as per reasons given in paragraph 16 Supra. There was strained relationship between the deceased couple and the accused after he accused brought home his second wife Santalata. The accused did not show any concern to shift deceased Ittai to the SC Medical College Hospital Kotak for specialized treatment, in spite of the fact that she referred to the SC Medical College Hospital Kotak by medical officers of Railway Hospital, Jotni and Jotni PSC at Sandapur. The false and inconsistent plea taken by the accused and his absconding after the IO period 13 lodged FIR Exhibit 17 implicating him in the crime are relevant on Section 8 of the Indian Evidence Act as conduct evidence. The Learned Defense Counsel has placed reliance in the case of Tanviban Pankaj Kumar Devetia versus State of Gujarat, AR 1997 Supreme Court 2193, wherein the mother-in-law and daughter-in-law with a child at arm were sleeping in two separate rooms which were interconnected, and the plea of the daughter-in-law was that in the fateful night the bungalow was stormed by the criminals who killed the mother-in-law and inflicted injuries on her and the child, ransacked her room from jewelry and cash, but left the house as they heard the sound of a moving vehicle. The daughter-in-law was convicted on Section 302 IPC by the session judge. The conviction was upheld in the appeal by the High Court of Gujarat, but the Apex Court acquitted the daughter-in-law on the ground that the daughter-in-law could not have inflicted injury to her 4-year-old baby, and barring few, the other injuries noticed on the daughter-in-law could have been self-inflicted and could not have been self-inflicted, and the deceased mother-in-law, who was an old asthmatic, was in the habit of coming out from the bedroom to the terrace to enjoy fresh air. The fact of the present case are widely different from those in the case of Tanviban Pankaj Kumar Devetia Chopra, and as such, the case law relied upon by the defense is not applicable to the facts and circumstances of the present case. No doubt, Santalata, the second wife of the accused, who stood trial under Section 302 and 201 read with Section 34 IPC in the ST case number 145 of 1997, has been acquitted by my predecessor, but her acquittal ipso facto does not give a clean sheet to the accused. In face of preponderant evidence as discussed supra, unerringly pointing to the guilty of the accused to the exclusion of the guilty of any other person. The accused has intentionally gave false information to the police in the FIR, reporting that the deceased couple warned over preparation of cake and threatened to kill each other in the fateful night. From the discussions made and reasons stated, I hold that the accused, due to strained relationship and avarice to get immediate access to the properties of the deceased couple, committed murder of the deceased Jadu and inflicted fatal injuries on Pitei in the fateful night leading to her death, and as such committed the offense of murder punishable under section 202 IPC. He has also committed the offense punishable under section 201 IPC by intentionally giving information to the police in respect of the offense which he knew to be false. In the result, I find the accused guilty. My lord, in this judgment, yesterday I was examining some statements of witnesses. Imaginary grounds are mentioned in the because there is no evidence on record that they had quarreled. And also, how could learned session judge found that for property they have done. So all these things, and also discarded the acquittal of co-accused. Both were husband and wife were accused. In a separate trial, co-accused wife was acquitted. So I have to also verify those things and bearded ticket, where he has taken 3 lines mainly. One, he did not take his mother to the SCB Medical College. In which circumstances he could not take, whether it was properly advised in the bearded ticket or not. So I have to examine. And also the other things, only one line is there in PW1 statement that they were not pulling well due to second wave.
Doctor of judgment is not paying.
Hostile, declare hostile.
Doctor.
My lord. Doctor, PW, I was just reading. I have only spent 2-3 hours yesterday, so I need some more time.
Yes.
And judgment, actually, the judgment cited is not applicable, but there are many judgments. Judgment, I think, must be in the line of defense. And the defense counsel, the appellant has prepared a good appeal memo where the grounds have been given. Unfortunately, he has died, my lord. Therefore, I have to support those affirmation in appeal memo with citations of Honorable Supreme Court and other things. Next week, I will prepare in a better manner. And to assist this Honorable Court, I want the LCR copy, if possible. I brought pen drive.
In future, the dead body, one there died, was
Injured.
Injured.
he was injured. And in that very house, you and your wife who have been acquitted, they were staying together.
My lord. It's a separate row.
The first group and this was the second group.
Pakka building.
So there was no other person. Like
ସେଇଟା ମୋତେ ଦେଖିବାକୁ ପଡିବ କାହିଁକି
this can't be acquitted.
ମୁଁ ଦେଖିଛି my lord.
Reference number 5.67
My lord.
Question number 12.
My lord. Acquainted
Case number 53.
acquainted respond better. Open. Judgment for correcting. My lord, question number?
Question number 6 onwards.
My lord, it further transfers from the evidence of Yogeshwar Sahu, Schedule 1, and Surendra Nath Subudhi, Schedule 2, that in the morning of 14/8/1996, they found deceased Jadu laying dead with bleeding injuries in his bedroom, while deceased Pitai was laying unconscious with bleeding injuries there. What do you say?
Yes.
Yes. कौन से लोग बुझंती एक्टिविटी में पहले में what do you say?
Question number 2.
Say means not admitted. What do you say?
Omane
नहीं मतलब से कहछि हमने से कहछि से कहया कथा हमने से कहछि ये सेंसर. It further transfers from the evidence of Surendranath Subudhi, Schedule 2, that you along with your second wife Santalata were present in the house of deceased. It is not denied. They were present. Out to 8, question number 8. It further transfers from his evidence that on being asked, you pleaded ignorance as to how deceased Jadu and Pitai sustained injury and how Jadu died. What do you say? Se coach innocent se janne ho? No. It further transfers from the evidence of Kishore Kumar Mahanti, Freedom 9, that you, along with your second wife, Santalata, were present in the house of deceased Jadu and Pitei in the night of occurrence. What do you say? Yes, they were present, my lord. It is not that they were not. It further transfers from the evidence of Prafulla Chandra Barik, the then IIC of Jotni PS 13, that at 6:10 a.m. on 14/8/1996, you lodged FIR Exhibit 14 at Jotni PS, informing that in the night of occurrence there was a quarrel between deceased Jadu and his deceased wife Pitei over the observance of Chittararanjan festival, in course of which they threatened to kill each other. And you, along with your second wife Santalata, pacified them, and in the next morning you found Jadu laying dead with head injury and Pitei laying unconscious with bleeding injury. That was fact. Question number 11. It further transfers from the evidence of SI of police T. Harikrishna Murthy, Freedom 14, that he visited the house of deceased Jadu Sahoo at 10:30 a.m. on 14/8/1996 and found Jadu laying dead with bleeding injuries on the floor of the bedroom, while his wife Pitei was laying unconscious with bleeding injuries in a pool of blood in the same room. What do you say? The fact of it further transfers from his evidence that the scientific officer collected blood stain by soaking it with threads MO1 and collected control thread by rubbing the head with the floor MO6. What do you say? It further transfers from his evidence that he sees the blood stained Khanati MO1 and broken bangles MO2 laying in the bedroom under the seizure list Exhibit 2 and 3. What do you say? Yes. Further transfers from the evidence of Dr. Dinakrishna Panda, Schedule 15, the then Assistant Surgeon Jotni PSC, that Pitei succumbed to the injuries at 4:30 a.m. on 15/8/1996 while receiving treatment in the PSC. What do you say? It further transfers from the evidence of Dr. Bimal Kumar.
Question number 28. No, sir, 29.
Have you anything more to say? Mo agoru mo bada bhai Jadura ପୁଅ ହୋଇଥିଲେ 1978 ମସିହାରେ ତାକୁ ହତ୍ୟା କରାଗଲା। ତାପରେ ଯଦୁ ଓ ପିତେଇ ମତେ ପୁଅ କଲେ। ଯେଉଁମାନେ ମୋ ଭାଇକୁ ମାରିଥିଲେ ସେମାନେ ଷଡ଼ଯନ୍ତ୍ର କରି ଯଦୁ ଓ ପିତେଇକୁ ମାରିଛନ୍ତି। निवेदन अभिप्राय कि मु प्रशांत साहू पिता जदू साहू ग्राम बाछड़ा पोस्ट जटणी जिला खोर्धा आज को प्राय 9 मास है मोर पिता से जदू साहू पोष्य पुत्र हो रही आसुची। मु रहा दिन ठार देखी आसुची मो पिता जदू साहू और माता पितेई साहू मध्य पारिवारिक घटना गंडगोल हुए। गंडगोल से परस्पर गालीगुलज और पिटामरा हमें ता देखी मु मोर स्त्री शांतलता साहू से बुझिया बुझी कले गंडगोल बंद करती ना। 13/8/1996 राति 8:30 शीत अमावस्या पर्व में पिठापणा न से घटना को केन्द्र कर राति 8:30 झगड़ा करते। पार्टी शुणी नीलू किशोर महांती घटनास्थल को आसी से मोर बापा माँ को झगड़ा बंद करने को बुझाई। झगड़ा समय मोर बापा जदू साहू मोर माँ पितेई साहू को गाली दे कही था आज रात ते जीवन मारिदेवी। सेहीपरि मोर माँ बापा को जीवन मारे धमक दे था। राति बेसी हेबारु मु मोर स्त्री आउ गोटे बखरा शोलु। सकाळ गोटे लाइन कटि जाइए। सकाळ देखले मरी पड़ी तार मुंड पाटी रक्त बाहर। पितेई साहू अचेत अवस्था पड़ी मुंड रक्त बहुची। ता देखी से मते उठाइले और कहले मु जाई देखिली मोर बापा जदू साहू शोईथिबा कोठरी भितर मरी पड़ी मुंड और पाटी रक्त बाहर। माँ पितेई साहू अचेत अवस्था पड़ी तार मुंड और पाटी रक्त बाहर। मु पाटी करी साई पड़िशा लोक डाकिली मो पार्टी शुणी आम साहिर श्री हरि साहू श्री सुर सुबुद्धि श्री सुधाकर महांती और श्री विद्याधर साहू घटनास्थल को आसिले से घटना देखि थाना दर्शाइबा थाना जणाइबा कहले मु थाना को आसिली और यही रिपोर्ट देउछि विनीत प्रार्थना करुछि यार तदंत करा जाऊ प्रकाश घटनास्थल मोर मार भंगा हाथ चूड़ी खंड पड़ी और गोटे खणती पड़ी झगड़ा होता
ସେମାନେ ପିଟା ପିଟା ହେଇକି ମାରିଲେ।
No, man, that my FIR version is supported by PW9, but as because he's a young man. झगड़ा होता पिठापड़ा मुझे पिठा न हबेनी
झगड़ा समय बापा गाड़ी ଦେଇଛନ୍ତି ଆଜି ତତେ
ମାରିଦେବି
ଏବଂ
ମାରିଦେବି
ଧମକ ଦେଇଛନ୍ତି ତେଣୁ ରାତି ବେଶୀ
ଏଇ କଥାକୁ ସପୋର୍ଟ କରିଛି PW9
this was your past three but we learned that
yes my lord ଏଇ କଥାଟାକୁ ବିଶ୍ୱାସ କରିଛନ୍ତି ଆର
କୌଣସି ଜାଗାରେ ଏଇ ଯୋଉ ଜିନିଷ ନାହିଁ
ଆମର
ତାପରେ ଯୋଉ ଲୋକମାନେ ଆସିଛନ୍ତି ଘଟଣା ଜାଗାକୁ immediately on to that you see what you have stated before that one by one
ମୋ ପାର୍ଟି ଶୁଣି ଆମ ସାହିର
ଏଠି ଅଛି PW1 my lord PW1 which is the I know the accused standing in the dock. I know the deceased Jadu Sahu and Pite Sahu. Oh, Jagdeshwar Sahu. No, I said na PW1. ମୁଁ ତା ଷ୍ଟେଟମେଣ୍ଟଟା ପଢୁଥିଲି ଜଗେଶ୍ୱର ସାହୁ ତାକୁ ବୟସ ହଉଛି 25 ବର୍ଷ ହଁ 25 ବର୍ଷ ଏଇଥିପାଇଁ ଦରକାର ଇଏ 25 ବର୍ଷ ଆ କଥାଟା ଭର୍ସନ ହେଲା ହଁ I know the accused standing in the dock.
ଯୋଗେଶ୍ୱର 39
ନା ଏଇଠି ଲେଖା ହେଇଛି 25
କୋଉଠି
ଏଇଠି PW1 ଏଠି ମୋର ଲେଖା ହେଇଛି ମୋର ଅଛି ଜେରକ୍ସ କପି ଯୋଉଟା ସପ୍ଲାଏ କରିଛନ୍ତି ପେପର ବୁକରେ 25 ବର୍ଷ ଲେଖା ହେଇଛି ହଁ ହଁ ଦେଖିଛି ସେଇଟା ସେ ଗୋଟା ହଉଛି ଧରିଛନ୍ତି ହଁ I know accused Prashant PW2 hoti 35 years. I know accused Prashant Sahu and his wife Shatrata Sahu. I also know this is Jadu Sahu, Jadu and Pitei. They were issueless. Jadu was working in the railways and was retired from service. Jadu had adopted Prabhata Sahu, the son of Pitei's sister. Prabhata predeceased Jadu. Jadu and his wife Pitei died in. My lord. Yes, my lord. PW2 January Surendra Subudhi. It is explication 145. नहीं से तारी सॉरी तार कनेक्टेड टाइला हाँ बुझिली सॉरी सेटा मु एटा ओहो इथरे
are you sure that you have received the paper
हम पढ़िछ केले तो ठीक सेटा रह जाईची I know the accused person as well as the deceased Jadu and Pitei. On 14th morning, I came to know that Jadu was dead and at 4:30 a.m. I went to their house and found that Jadu was laying dead and his wife Pitei was laying unconscious and both the deceased and injured Pitei sustained bleeding injuries. The accused and his wife were present in that house. I asked the accused as to how Jadu died. He replied that he did not know.
this is most important
से जानने से सोईती हो
ପୂର୍ବ
ଦିନ ଯାଇଥିଲି
ଯେତେବେଳେ ଆପଣ ଆସିକି ଇଏ ପହଞ୍ଚୁଛି ସକାଳୁ
ସେ ପଚାରିକି କେମିତି ମଲେ ସେ ସେଇଟା କହିପାରିନି କେମିତି
କଣ କହିଥାନ୍ତୁ ବାଟୁଟି statement?
ସେ କେମିତି ଜାଣିଲେ ସେ ଗୋଟେ କମ୍ପାଉଣ୍ଡ ଆଗରେ ଗୋଟେ ରୋ ଅଛି ପଛରେ
ଏଫଆଇଆର ତାର ସମୟ ପରେ ଯାଇ ଏଫଆଇଆର ଦଉଛନ୍ତି ସେ
ହଁ।
କହିଲେଣି ଯେମିତି ପୂର୍ବ ଦିନ
ଝଗଡା ହେଇଥିଲା ପୂର୍ବ ଦିନ ଝଗଡା ହେଇଥିଲା
Transaction
ହଁ ସେଇଟାକୁ ସେ ସିରିୟସଲି ଭାବିନି କିଏ ଭାବିନି କିଏ ମାରିଦେଇଛି
ଆପଣ କହିଲେ immediately after the occurrence.
ହଁ
So that is also very
ହଁ ଭେରି ରିଲେଭେଣ୍ଟ ସେଇଥିରେ
ସେତେବେଳେ ଆସିକିରି ପଡୋଶୀ ମାନେ ପହଞ୍ଚୁଛନ୍ତି ପଡୋଶୀ ମାନେ ପଚାରୁଛନ୍ତି କେମିତି ଇଏ ମଲା
ହଁ
ମୋ କହିବା କଥା ଯେ ଗତକାଲି ରାତିରେ ଏମିତି ବାପା ମାଙ୍କ ଭିତରେ ଏମିତି
ସେଟା ଏଫଆଇଆର ଲେଖିଛି
ଜଣକୁ ଧମକ ଦେଇଛନ୍ତି ଆଉ
ସେ ସେଇଟାକୁ ତା ମାଇଣ୍ଡରେ ଗୋଟେ ରହିଛି ତା ଭାଇକି ଯିଏ ମାରିଥିଲା ଇଏ ବୋଧେ ସେଇ ମାରିଛନ୍ତି ତା ମାଇଣ୍ଡରେ ରହିଛି ଯୋଉଟା ସେ ଆକ୍ୟୁ ଷ୍ଟେଟମେଣ୍ଟ କହିଛି ତେଣୁ ସିଏ ସେତେବେଳେ ଗୋଟେ ହଁ
cannot be taken as a state, but what you will anticipate will be a plea.
ନାଇଁ ଦେଖିଲା ମରି ପଡିଛନ୍ତି କେମିତି ମରି ପଡିଛନ୍ତି ସେ ଜାଣିନି
He also saw what transpired in the previous night.
ହଁ
He was present.
ସେଇଟା ସେ କହିଛି
Present ଥିଲା।
ହଁ
ବାପା ମା ଯେତେବେଳେ ଝଗଡା କଲେ ସେ ଛଡାଛୁଡି କଲା ତା ସେକେଣ୍ଡ ୱାଇଫ ବି ଛଡାଛୁଡି କଲା
ଇଏ
ସେମାନେ ଦି ଜଣକୁ
ହଁ ସେଇଟା ଠିକ
ଠକିଲେ ଯେ ମୁଁ ତତେ ମାରିଦେଲି
ହଁ ସେ ମାରିଦେଲି
ତେଣୁ ସେ ପ୍ଲେଟାକୁ
ସେ ପ୍ଲେଟା ସେ ହୁଏତ କହିନି ସେଇଟା ହୁଏତ PW2 ପୋଲିସ ଯୋଉ ଲାଇନରେ ପଚାରି ସେ ଏତେ କଣ ହେଇଛି ନାଇଁ ଗୋଟେ ସେକେଣ୍ଡ ଖାଲି ଏଥିରେ ମାଇଲର ହ୍ୱାଟ ହ୍ୟାପେଣ୍ଡ ଓରିଜିନାଲ ଏଫଆଇଆର ଗୋଟେ ଇନଭେଷ୍ଟିଗେସନ ହେଇଥିଲା ଏଟା 6 ମାସ ପରେ ଆଉ ଗୋଟେ ଏଫଆଇଆର କରିଛନ୍ତି ଆଇଏସି ନିଜେ ସିଏ କରିଛନ୍ତି ଯାକୁ ମୁଁ ତା ଖବର ପାଇଲି ଯା ଖାଲି ମାନେ ଶୁଣିଥିଲି
ସେ ଯୋଉ ଇଏ ଷ୍ଟୋରି ଶୁଣାନ୍ତି ଖବର ପାଇଲା ଏଭିଡେନ୍ସରେ ଯାହା ଅଛି
ହଁ ଏଭିଡେନ୍ସରେ ଅଛି ସେ ଦିଟା ଏଫଆଇଆର ଏଥିରେ ଗୋଟେ ଏଫଆଇଆର ଥିଲା ୟାଲିୟର ଯୋଉ ଏଫଆଇଆର ରେ ଥିଲା ସେ ଏଫଆଇଆର ଦେଇଥିଲା ଇଏ 6 ମାସ ପରେ ହଁ ସାର୍
on record.
ହଁ
Where is that?
PW ଆମର ପେପର ବୁକ୍ ରେ ଅଛି ଦିଟା ଏଫଆଇଆର
Yes, my lord. Initially, the present accused lodged an affair alleging that
ଏଇ କେସଟା
during investigation,
ପୋଲିସ ଅଫିସର
during investigation, police found the involvement of the present petitioner. Thereafter, police lodged the affair.
ତେଣୁ ସେଇ ଏଇ କେସର ଏଫଆଇଆର ଟା ସେଇ କେସ ଏଫଆଇଆର ଟା ହଉଛି ପୋଲିସର ଏଫଆଇଆର ଟା ହଁ ତେଣୁ ସେଇଥିରେ କଣ ପୋଲିସ ଯେ ଆଗ ପୋଲିସ ଯିଏ ଭାବିଥିଲା ଅଲଗା ଇଏ ଭାବିଲା ଅଲଗା ମୁଁ ତା ମାନେ ଭାଇ ଇଏ ତାକୁ ସାଟିସ୍ଫାଇ କଲେନି ବୋଲି ସିଏ ଆକୁ ପକେଇବା ପାଇଁ ସବୁ ପ୍ରକାର ଖାଲି କେସଟା ତିଆରି କଲେ ଏବଂ ସେଟା 6 ମାସ ପରେ ସେ ଏଫଆଇଆର ଟା ଏଥର ଘଟଣା ଘଟିବାର 6 ମାସ ପରେ ଫେବୃଆରୀ ନା କଣ ହେଇଛି ଏଟା ହଉଛି ଅଗଷ୍ଟ ମାସରେ ତେଣୁ ସେଇ ଯୋଉ ଏଫଆଇଆର ହେଇଛି ସେ ଅନୁସାରେ ସିଏ ଯାହାକୁ ଦେଇଛି ସାକ୍ଷୀ କରିଛି ସିଏ ତାକୁ ପଚାରିଛି ଘଟଣା ବିଷୟରେ କେମିତି ମଲା ଇଏ କହିଛି କେମିତି ମଲା ମୁଁ ଜାଣିନି କିନ୍ତୁ ଗତ ଦିନ ଆଗଟା ଯେ ରେଲିଭାଣ୍ଟ ଇଏ ସାଧାରଣ ଲୋକଟେ
ଆଉ ଗୋଟେ କଥା ଆପଣଙ୍କର ଯୋଉ କେସଟା ଫି ନେଇଛନ୍ତି ଏଫଆଇଆରରେ
ଆଜ୍ଞା
ଆପଣଙ୍କ ଇଏ ତାକୁ ମାରଲା ସେ ତାକୁ ମାରଲା
ନାଇଁ ଆମେ ବୋଧ ହୁଏ ସେ କହୁଛି ହଁ
ଯଦି ସେଇଆ ହେଇଥାନ୍ତା ୱେପନ ହଉଛି ଗୋଟିଏ
ସେ ୱେପନ ହେଇନି କିଛି ହଁ
ଯଦି ୱେପନ ତ ୟୁଜ ହେଇନି
ହେଇଛି ୟୁଜ ହେଇଛି ସେ କହୁଛି ତାର ବେଣ୍ଟର ହେଇଥିବ ହଁ
ଏଥିରେ ମରା ହେଇନି
ହଁ
ତ ସେଇ ଯୋଉ ଜଣଙ୍କ ହାତରେ ଯଦି ଆପଣଙ୍କ ପ୍ଲିଟାକୁ ଆକ୍ସେପ୍ଟ ହୁଏ ପ୍ରଥମେ ଜଣେ ମାରିଥିବ ତାର ଦ୍ୱିତୀୟ ଲୋକଟା ତାକୁ ଛଡେଇକି ମାରିଥିବ ଦିଟା ୱେପନ
ଆଉ ଗୋଟେ କିଏ ନେଇଯାଇଥିବ କଣ ହେଇଛି କି
ସେ ଯୋଉ ଗପ କହୁଛନ୍ତି
ନାଇଁ ସେ ମୁଁ ତାକୁ ଦେଖିବି ଗୋଟେ କେସରେ ସେମିତି ହେଇଥିଲା ମୁଁ ତାକୁ ବାଗେଇ ଦେଖିଲି ହଁ
ଚାରି କାନ୍ଥ ଭିତରେ ହେଇଛି
ନାଇଁ ଚାରି କାନ୍ଥ ଭିତରେ ନୁହେଁ
ଆଉ କେହି ଲୋକ ତା ଭିତରେ ପଶିବାର
ନାଇଁ ସିଏ କହିଥିଲା ଦିଟା ଯୋଉ ରୋ ନାଇଁ ତା ଭିତରେ ଏମିତି କମ୍ପାଉଣ୍ଡ ଥାଏ ଯୋଉଟା ସେଠି ଆକ୍ସେସିବୁଲ ବି ଥାଏ ତେଣୁ ସ୍ପଟ ମ୍ୟାପ ପାଖରୁ ଆରମ୍ଭ କରି ସବୁଗୁଡା ଦେଖିବାକୁ ପଡିବ
ସ୍ପଟ ମ୍ୟାପ ଦେଖୁଛି ଫ୍ରଣ୍ଟରେ ଆଜବେଷ୍ଟସ ଘର ଅଛି ବାକି କମ୍ପାଉଣ୍ଡ ଅଛି ପଛରେ ବୁଲାବୁଲି ରହୁଛନ୍ତି ଏଣ୍ଟ୍ରାନ୍ସ
ହଁ ସେଇଟା ଯେତିକି ମୁଁ ବାଗେଇ ଟିକେ ଏକ୍ସାମ କଲେ ହଜର ମୁଁ କହିପାରିବି କାହିଁକି ମୁଁ ଗୋଟେ କେସରେ ଗୋଟେ ଗଳା ଭାଙ୍ଗି ଯାଇଥିଲା ଥରେ ହଁ ଆଜ୍ଞା ହଁ ଏ ଯୋଉ କମ୍ପାଉଣ୍ଡ ଅଛି ହଁ
ଏଣ୍ଟ୍ରି ପଏଣ୍ଟ ଆଗେ ଅଛି ଏଣ୍ଟ୍ରି ପଏଣ୍ଟ ହଉଛି
4 number
14 ରାଇଟ୍ ସାଇଡ୍ ହଁ ଏଇଠି ଅଛି ହଁ
ଘରେ ତାମାନେ ପଶିବାକୁ ମାତ୍ର ଗୋଟିଏ ପଏଣ୍ଟ ଅଛି
ହଁ ହଁ
ସେଟା ହଉଛି 14 ନମ୍ବର
ହଁ
କୌଣସି ପଟେ ନାହିଁ
ସେଇ ଯୋଉ ହଜର ସେଇ କଥା ମୁଁ ଟିକେ ଏକ୍ସପ୍ଲେନ କରିଦଉଛି
ଆପଣ ଆଗେ ଦେଖି
ହଁ ଦେଖି ସାରିଲିଣି ହଁ ହଁ
14 ନମ୍ବର ଅର୍ଥାତ ସେଇ ପଟ ଦେଇକି ଆସିଲା ପରେ ଏଠି ହଉଛି ଜଣେ ଆସିବ ନମ୍ବର 8 ମାନେ ହଉଛି ସାଇଡ ବାହାରେ
my lord 14 number ଟା ହଉଛି ପଛ ଆଗରେ ଅଛି ନା 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 ଅଛି କହୁଛି 4 ନମ୍ବର ଯୋଉ ରୋ ଅଛି 4 ନମ୍ବର ରୋଟା ଫ୍ରଣ୍ଟ ବାରାଣ୍ଡାରେ ଗୋଟେ ଏଣ୍ଟ୍ରାନ୍ସ ରୁମ୍ ଅଛି ହଁ 4 ନମ୍ବର ସେଇଟା ହଉଛି ଏଣ୍ଟ୍ରାନ୍ସ 14 ନମ୍ବରଟା ହଉଛି ଆଉଟର ଦିଟା ବାଟ 14 ନମ୍ବରଟା ବ୍ୟାକ୍ 10 ନମ୍ବରଟାରେ ଆକ୍ୟୁଜଡ ରହୁଛି 3 ନମ୍ବରରେ ରହୁଛନ୍ତି ହଁ ସେଠି ଇନ ଦ ମିଡିଲରେ ଗୋଟେ ଇନର ବାରାଣ୍ଡା ଅଛି 10 ନମ୍ବରରୁ 8 ନମ୍ବର ଯୋଉ ପଏଣ୍ଟଟା ସେଟା ଗୋଟେ ଇନର ବାରାଣ୍ଡା ପୁଣି 5 ନମ୍ବରଟା ଆଉ ଗୋଟେ ଇନର ବାରାଣ୍ଡା ସାଇଡ ବାରାଣ୍ଡା ସେଠି ଆଉ ଗୋଟେ ବାରାଣ୍ଡା ଅଛି ତ 10 ନମ୍ବରରୁ 3 ନମ୍ବରକୁ ଯିବା ପାଇଁ ଦେयर ଇଜ ନୋ ଅବଷ୍ଟ୍ରକ୍ସନ 10 ନମ୍ବର ରୁମ ରୁ ବାରାଣ୍ଡା ବାଟଟା ହଁ ଫାଙ୍କା ଅଛି ଆରାମସେ 3 କୁ ଯାଇ ହବ 3 କୁ ଯାଇପାରିବ ଆଜ୍ଞା yes internal ବାରାଣ୍ଡା 6 ନମ୍ବରଟା କୂଅ ସେଟା କୋଟିଆଡ ସେ ଏରିଆଟା କୋଟିଆଡ ଅଛି my lord the accused person they are staying on room number 10 and deceased were lying on room number 3 if there was any quarrel it is quite possible that must have listened by the accused my lord they have never intervened on the thereafter their action my lord conduct on the morning the accused found that his father and mother they are laying injured and father dead mother alive he instead of taking the mother to the hospital he going to the file the FIR lodging the a false allegation that they were thereafter but conduct his conduct should be yes
ସେଟା ସେ କହୁଛି ସେ ସେମିତି କ୍ରିଟିକାଲ ସେ ପୋଲିସ କୁ ଡରିକିନି କହିଛନ୍ତି
survival of the person mother or more importantly to go for the hospital ତାକୁ ନ କହିକିନି ତାକୁ ଛାଡି ମା ଖୁସି ଅବସ୍ଥାରେ
ସେଟା ମୁଁ ଦେଖିବି ଟିକେ ସଜୁଟି ସେ ଦେଖିବି ତମେ
ଆଜି ଜଜମେଣ୍ଟ ଦେଇଛି
ହଁ ସେ ନାଇଁ ସିଏ ଗୋଟିଏ 3ଟା 4ଟା ଯୋଉ ପଏଣ୍ଟ ଦେଇଛନ୍ତି ସେ ପଏଣ୍ଟର କଣ ଅଛି କାହିଁକି ସେଟା ହେଲା ସେଟା ମୁଁ ଟିକେ ଦେଖିଲେ ବି ଜଣା ପଡିବ ଗୋଟେ କେତେ କଣ ହେଇଥିଲା ଯୋଉ ଚାରିପଟ ଯେତେବେଳେ ଅଛି ଯେମିତି ଗୋଟେ ଭଙ୍ଗା ଥିଲା ସେ ଭଙ୍ଗାରେ ଆସିକି ସେ ମାରିଥିଲା ସେଟା ପ୍ରମାଣିତ ଥିଲା ସେ ଆକୁଟା ହେଇଥିଲା ତେଣୁ ମୁଁ କହିଲା ସବୁ ସାକ୍ଷୀ ଦେଖିବାକୁ ପଡିବ ଟେକ୍ନିକ ଦେଖିଲେ ତାପରେ ପାଇହବ
the circumstance are summarized at page 20
ନା ସେ ତ ମୋର ଭାବିଛନ୍ତି ଆଉ ଇଏ ଗିଲ୍ଟି ବୋଲି ଆଉ ସେଥିରେ ଏମଆର ପଟ୍ଟନାୟକ ଭାବି ଆଗରୁ ସେ ଆକୁଟା ହେଇଛି କେମିତି କୁହନ୍ତୁ ନାଇଁ previous learned session judge acquitted the wife हाँ ବୁଝିଲି
accused has not taken any plea that
ଆପଣ ଯୋଉଟା ପଢି ଦେଇଛନ୍ତି ବୋଲି କହୁଛନ୍ତି ମୁଁ ଟିକେ ବାଗେଇ ପଢି ସାର ଆରଥରକୁ କହିବି ମୁଁ କହୁଛି କାହିଁକି ନା ମୁଁ ଟିକେ ବାଗେଇ ପଢିନି
ନାଇଁ ସେ 299 ରେ ସେମ୍ ଏଭିଡେନ୍ସ
ହଁ ସେଇଟା ନାଇଁ ସେଇଟା ଆକ୍ସେପ୍ଟ ହେଇନି ଆଉ ଥରେ ହେଇଛି
separate
ନାଇଁ ଖାଲି ସେଇଟା ଟିକେ ଦେଖିବି ଟିକେ ଦିଟା
separate
that is been a question of adoption under 299 ସେ
ନାଇଁ ସେଇ ଯେ ଏଥିରେ ବହୁତ ଗୁଡା ଡାଉଟଫୁଲ ଅଛି ତେଣୁ ଡାଉଟଫୁଲ ହେଲେ ସେ ତ ବେନିଫିଟ ନବ ନା ଆକ୍ଚୁଆଲି ସେ ତ ପ୍ରୋସିକ୍ୟୁସନ ପ୍ରୁଭ କରିବ ନା ଆମେ ପ୍ରୁଭ କରି ଇଏ କେଉଁ ଲୋକଟା ପ୍ରକୃତରେ କେମିତି ଭଲ
here little different
ହଁ ଟିକେ
you are the informant
yes
and certain thing has come from your sources so unless those aspects are proved
ମୁଁ
ଜିନିଷ ଆପଣ admit କରୁଛନ୍ତି
ନାଇଁ
ଆପଣ ପ୍ରେଜେଣ୍ଟ
not present disputed me
ବାପା ମା ସେଇ ଘରେ ହିଁ ଘଟଣାଟା ହେଇଛି
not disputed
ୱେପନଟା ମଧ୍ୟ ସେଇ ଘରକୁ ବାହାରିଛି
ସେଟା ୱେପନ ଅପରଚୁନିଟି ନିଜେ କୋର୍ଟ ଡିସକାର୍ଡ କରିଛନ୍ତି
ସାର୍ଟ ସାଇଡରେ ୟୁଜ ହେଇକି
ନାଇଁ ପୁରା ଡିସକାର୍ଡ କରିଛନ୍ତି ପୁରା ଡିସକାର୍ଡ କରିଛନ୍ତି ୱେପନଟାକୁ ଏଇ ୱେପନ ଅଫ ଅଫେନ୍ସକୁ
ସାର୍ଟ ସାଇଡଟା
ନାଇଁ ଦିଟାକୁ ଡିସକାର୍ଡ କରିଛନ୍ତି ମାନେ ସେଟା ଆସିଥିଲା ଏଭିଡେନ୍ସରେ କିନ୍ତୁ ହଁ ମୁଁ ଦେଖୁଥିଲି ଯୋଉଟା ମୁଁ ପଢୁଥିଲି ଯୋଉଟା ପଢୁଥିଲି ଜଜମେଣ୍ଟଟା ସେ ଜଜମେଣ୍ଟରେ ସେ ତାକୁ ଡିସକାର୍ଡ କରିଦେଲେ
the paragraph number 14.
हाँ जी
Internal page is 14, now roaming page is 27.
हाँ नहीं 14 पैसे जी
The one was sent
For chemical
examination. Chemical examination report reveals that Boston pillar
हाँ
and it was insufficient.
কিন্তু কোর্ট তো ডিসকার্ড করেছেন
Both the doctors conducting autopsy have opined that
To find that actually the handle of the column.
हाँ
I mean, that is the
Opinion.
of the doctor.
Hmm.
But used to infix one so
my lord my kindly say last sentence I therefore discard the MO1
that is not the final. He may accept it. That the one side.
মানে সেটা অ্যাকসেপ্ট করেন সে ডিসকার্ড করে
Trial court করলেন।
লাস্ট সেন্টেন্স
Trial court যাওয়ার পয়সা সেটাও কি
না না হ্যাঁ সেটা
সেটাও কি
আমি বুঝছি না
you can differ from the conclusion that
হ্যাঁ ইয়েস ম্যাম ডেফিনেটলি ମୁଁ ଦେଖୁଥିଲି ସେଇଠୁ ଦେଖିକି ଦେଖି ଖାଲି
what he says that the opinion of the doctor therefore roots out use of iron
ହଁ
ସେଟାକୁ ଇ କରି ପୁରା କେମିତି discard
ସେ କରିଦେଲେ ବା ଲେଖିଛନ୍ତି ଆଇ therefore discard the MO1 as the weapon of offense
ସିଏ discard
ଆପଣ କରିବେ ହଁ ହଁ
but
ହାଇକୋର୍ଟ କରିବେ
there must be some reason
ସେ ଦେଇନି
doctor କହୁଛନ୍ତି ଯେ front side ରେ ହେଇପାରିବ sharp side ହେଇନି କାରଣ କୌଣସି କଟ୍ କିମ୍ବା side କୁ ନାହିଁ
ହଁ ମ୍ୟାମ୍
last side ରେ ମୁଁ ଅଛି
ଠିକ ଅଛି
ଇଏ କଣ ଏକାଟା କେମିତି discard
କରି ଦେଇଛି ସାର୍ ହଁ ହଁ ଠିକ ନିଶ୍ଚିତ ଡେଫିନେଟଲି ହଁ ହଁ ସେ ନିଶ୍ଚିତ ମୁଁ ସେୟା ଦେଖୁଥିଲି ଯେ କଣ୍ଟ୍ରାଡିକ୍ଟରି ତା କଥା ବି କଣ୍ଟ୍ରାକ୍ଟ ଲର୍ଣ୍ଣେଡ ସେସନ ତ ତା ଜଜ କଣ୍ଟ୍ରାଡିକ୍ଟେଡ୍ ହିଜ ଓନ୍ ଥିଙ୍ଗସ୍ ସେଥିପାଇଁ ଟିକେ ବାଗେଇକି ମୁଁ କରିଦେଲେ ତାକୁ ଜଷ୍ଟିସ୍ ପାଇବ ଲୋକ ଅଲରେଡି ୱାନ୍ ଆକ୍ଟୁଟେଡ୍ ତେଣୁ ଡାଉଟ୍ ଅଲରେଡି ଆସିଗଲାଣି ତେଣୁ ଏଇଟା କେମିତି ହେଇଛି ଆଉ ଟିକେ ଦିଟା କମ୍ପେୟାର କରିକି ମୁଁ କହିବି
the wife is standing on some different.
ହଁ ହେଲା ନାଇଁ ଏକା
Wife has not lodged the affair before the police station.
wife first saw the incident she told the incident to the husband ତେଣୁ ୱାଇଫ୍ ତ ଆକୁଟାର ହେଲାଣି ତେଣୁ ଏଇଟା ମଧ୍ୟ ଡାଉଟଫୁଲ ହବ ଦେଖିବା ଆପଣ ଦେଖିବା ଆପଣ ପଢିବେ ମୁଁ ଟିକେ ପଢିଦେବି
That apart the conduct of the petitioner soon after ମୁଁ ତ ଟିକେ କହିଲା
ଆଜି ଟିକେ କୁହନ୍ତୁନି ଆଉ କହିବେ ମୁଁ ଟିକେ
listening very carefully
Man.
so that you can prepare yourself.
yes man ଠିକ ମୁଁ
The
ଭାବୁଥିଲି
most important thing which you are required to listen from the judges from the other side so that you are getting the time to prepare.
yes exactly I since my
Don't,
ନାଇଁ ମୁଁ କହୁନି ମୁଁ କହୁଛି କଣ କି
sufficient.
ମୁଁ ଖାଲି କହିଲି ଟିକେ ସେ ଯୋଉ ଆপিଲ ମଟା ପଢିଥିଲି
You come out of that word. You listen to the what we are posing to you,
ହଁ ହଁ ହଁ
and you have to answer it.
I will answer.
Get success. You are the counsel who is arguing a appeal. By preparing the appeal, should first prepare that what the other counsel is to make this
ପ୍ରିପେୟାର
submission.
କରିଦେଇ ସାରିଲା
ସେଇଟା ହଉଛି ପ୍ରଥମ ଡ୍ୟୁଟି ତାର
ହଁ
ସିଆରେ ମତେ ଏଇ ଗୁଡାକ ମତେ ମିଟ୍ କରିବାକୁ
ହଁ ହଁ ହଁ
ମୁଁ ଆଗେ ମୋର ପାଖରେ ଯାହା ଅସ୍ତ୍ର ଶସ୍ତ୍ର ଅଛି ଠିକ ଅଛି
ହଁ
ବଟ୍ ଅପୋଜିଟ ସାଇଡ ପାଖରେ ଏଇ ଅସ୍ତ୍ର ଗୁଡାକ ଅଛି ମୁଁ ତାକୁ କେମିତି ରିଟାଲିଏଟ କରିବି ସେଥିପାଇଁ
ସିଏ କହୁଛନ୍ତି ଜଜମେଣ୍ଟ ଯାହା ଲେଖା ହେଇଛି
ପ୍ରିପାରେସନ ହେଲେ କିଏ ଜିତି ପାରିବେ
ନାଇଁ ସାର୍ ସେ ଜଜମେଣ୍ଟଟା ପଢିକି କହୁଛନ୍ତି ମୁଁ ସେଟା ପଢିଛି
Yes, sir. Yes, Mr.
after registration of the affair against the accused person immediately the accused fled away that is also one another circumstance against the
How many days after he received?
my lord the first the affair was lost by the accused on
No, FIR ତ ଅଛି ଆରେ
ଦିଟା affair
ନାଇଁ ଏଇ FIR ଟା ତ
by the ପ୍ରଶାନ୍ତ ସାହୁ ଦେଲେ
ହିସାବରେ ନିଆରେ
yes
କେସରେ ଆମ ଜଜମେଣ୍ଟ ଆମେ ଦେଖୁଥିଲୁ ଜଜମେଣ୍ଟ ର ଯୋଉ ଲାଷ୍ଟ ସେକ୍ସନରେ ଯୋଉ ଏକ୍ସିବିଟ୍ ମାର୍କ ହେଇଛି
exhibit 15 ହଉଛି affair
exhibit 40 exhibit
15
15 ଟା ହଉଛି ଫର୍ମାଲ FIR ତା ବେସିସରେ କପି ଟା କଣ exhibit ଟା
ଏକ୍ଜିଟ୍ 40 ଟା ହଉଛି ଏଫଆଇଆର
ରେଜିଷ୍ଟର ବି କୋଉଟା
ଏଠି 14 ଲେଖା ହେଇଛି
କୋଉଟା ନେବି ସେ ଯୋଉ
14 ହଉଛି ଆର
ଫର୍ମାଲ
ହଁ written report ଟା 14 formal affair 15
FIR
Formal affair 15. 18 is the yes. Yes. 15. Exhibit 18, my lord. Exhibit 18. Exhibit 18. 18. No. That is the affair lost by the police, where the present petitioner and his wife are accused. Ayub 13. 13.
Paragraph number 2 on so and so accused presented FIR before the IAC and it was registered as so and so. So in case re FIR accused FIR to it's not that some other FIR. I basis re investigation proceed to inquest and the number down to the 150 of trial. Say before basis re some more number achieved complete.
My lord, but Jotani PS case number 25 of 97.
Data A2
302 201 34 IPC case registered. This case judgment, my lord, arising out of Jotani PS case number 25 of 97. This judgment arising out of Jotani PS. Yes.
Investigation start.
Yes, 152. Yes.
But you cannot say that FIR start police you know.
No, FIR originally tapor.
FIR accused FIR
There also been agreement on that day. When was the expert?
সেটা সে আসছে আন্টিসিপেটরি বেল এর ফাইল অপিল মেমোরি মু দেখি যা সে আন্টিসিপেটরি এর বেল ফাইল ହେଇଥିଲା ସେ ମୁଭ କରିଥିଲା ସେ ଆବସେଣ୍ଟ କରିନି ସେ ତା ସ୍ତ୍ରୀର କେସ୍ ବୁଲୁଥିଲା
My lord, P13 of paragraph 13. In spite of my best effort, I could not arrest the accused as he absconded after 5/2/97. On completion of investigation, I submitted charge sheet against the accused, declaring him as an absconder.
ये তারপর আউট কেস করতে সেটা সে জানে
High to 97 the Jotani PS case number 25 of 97 was registered.
So long the investigation continued on the basis of his report.
He remained.
Was present.
Yes.
The moment the investigation turned,
Yes.
where he was found to be one of the accused.
Yes, he absconded. Yes.
So, but the case is quite August to February.
Yes.
August ଥିଲା ଆଗରୁ ଯାଇଛି ଥାନାକୁ ଯାଇଛି ସବୁ ବାରମ୍ବାର ଯାଇଛି
Paragraph number BW13 wrong. Paragraph number 5 correct. You can be recover investigation from BW14.
Yes.
But one paragraph 5 correct.
I also made query to Dr. A.K. Patra, PW7, as to whether the injury received by deceased Pitei Sahu can be caused by same Khonati MO1 by requisition Exhibit 10. I received his opinion by Exhibit 10 by 1. On the basis of investigation made by me, the previous IO THK Murthy and the previous IO THK Murthy and came to the conclusion that the incident did not happen as reported by accused in his FIR Exhibit 14. But accused himself was author of the crime for which I lost FIR Exhibit 17 on 5/2/1997. Whereupon Jotni PS case number 25/97 was registered. Exhibit 17 by 1 is my signature on the FIR lodged by me. 150 day.
সেটাই।
investigation
5/2/97 second,
Schedule 13.
kind of the I made over the chart that you can get also even 14 I received the report on what we started paragraph 11 and that of the 2009 started upon my transfer to special branch I made over the charge of investigation transfer there. You don't practice every investigation over so on.
Date type consider investment from him 5/11 paragraph 2 PW 13.
Investigations from Sodo are 96 to
5/11/98 again 18 page paragraph 2 of each statement.
actually you don't continue actually.
Yes.
The line of paragraph 13 is the
96 হবা কথা সেটা ভুল টাইপ হয়েছে 14/8
96 হবনি 96 কি দেখ 5/2/96
14/8/96 ର Exhibit 15 my lord 15 হচ্ছে ফর্মাল এফআইআর লস বাই ডি সেটা 14/11/96 পুলিশ যেটা দেলা that is 5/2/97 5/2/97 Exhibit 17. সেটা টাইপোলজি ভুল হয়ে যাচ্ছে 5/11/96 হব consequent upon transfer of SIT Tarakrishna, I took investigation from him on 5/11/96. Yes. That should yes.
Oh, 97.
अच्छा ये नेला परे paragraph 13 रे कौची से आई हो जो PW 13 पड़े
Through 13 again. In fact, of my make it.
only the कौची
This Sultana looks at on the day when the affair was lost from time to time.
That's okay. Very good thing. Very good.
if I registered it Dana they you know say Dana of the stream and it doesn't feel from chassis the version of the final form.
The charge with that. That's good.
Situation declaration
These can educate will लिखा है. Yeah, that's good.
five also popular. That's one. On just the last one, you know.
The briefly that I will be. Is matter to take now.
You already shot the next, you know, saving RST for the probably shot by you.
Yeah, and usually I'm suitable coach. You know, Ferrer the thing. Oh, it's yeah. Very honestly. It's up on that. That's what it is. Take it up. Producing custody. Appeal ମାନେ ପ୍ରଶାନ୍ତ
17/12/18 ଚାର୍ଜସିଟ୍ ଟା ପୂର୍ବରୁ ହେଇଛି 5/5/17
ନାହିଁ ମୁଁ ଅପିଲରେ ମେମ୍ବର ପଢୁଥିଲି ମୁଁ ପୁରା
File
ବାଗେଇ
କରିଥିବ।
ଦେଖିଲି ଦେଖିଲି
ଫାଇଲ
ସେମାନେ ଆଣ୍ଟିସିପେଟ ବୋଲି ମୁଁ 3 ମାସ ଘଟଣା ରିଜେକ୍ଟେଡ ହେଇଯିବ କି ୱିଥଡ୍ର କରିଥିବେ ହଁ ମାନେ ତାପରେ ସରେଣ୍ଡର କରିଛି
ଆରେଷ୍ଟ ହେଇଛି
ନାଇଁ ଆରେଷ୍ଟ ମାନେ କୋର୍ଟର ସେ ହେଇପାରିନି ବୋଲି ଆଣ୍ଟିସିପେଟ ବୋଲି ସରେଣ୍ଡର କରିଛି ଆଉ କଣ
ପ୍ରଡ୍ୟୁସ ହେଲା ବା
ହଁ ପ୍ରଡ୍ୟୁସର ଆରେଷ୍ଟ ହେଲେ ପ୍ରଡ୍ୟୁସ ଦେଖାନ୍ତି ସେ କେବେ ଦେଖନ୍ତିନି ସରେଣ୍ଡର ବୋଲି ତିନି ମାସ କାଳ
ନା ବର୍ଷେ 6 ମାସ 1.5 ବର୍ଷ ବେଶୀ 5/2/97 FIR ପ୍ରଡକ୍ସନ ହେଲା 3/11/98 ତାମାନେ ବର୍ଷେ 8
ସେଇ ସମୟରେ ସ୍ଥିର ଟ୍ରାଏଲ ଚାଲୁଥିଲା
10 ମାସ ବର୍ଷେ 10 ମାସ
he was looking after his wife's share. ନାଇଁ ଏଇ କେସର ତଥାପି ସାର୍ ହଜୁ ଟିକେ ନିଶ୍ଚୟ କାମ ଲାଗିବ ବୋଧେ ମୁଁ ଭାବୁଛି ହଁ ସେଇଥିରେ ଅଛି ବୋଧେ ଅଛି ଜଜମେଣ୍ଟ ବି ଅଛି ଡିସ୍କସନ ହେଇଛି ହଁ ଏଭିଡେନ୍ସ ଆସିନି ସେଠାରେ ହେଇନି ମୁଁ ତାକୁ ଆଣିବି ଏଥିବି ମଧ୍ୟ ଯେମିତି ଆଉ ସେଇଥିରେ ବି ଯଦି କିଛି ଆଣିପାରିବି ତାହେଲେ ମୋତେ ଦେଖା ହେଇପାରିବ ଯଦି ଥିବ ନେକ୍ସଟ ମଣ୍ଡେ ନେକ୍ସଟ ଟ୍ୟୁଜଡେ ହେଲେ ଭଲ ହନ୍ତା ଆଉ ଟିକେ ସମୟ ପାଆନ୍ତି ମତେ ସେ ଯୋଉ ଏକ୍ଜିକ୍ୟୁଟ କପିଟା ଆଉ ଇଏ ଚାର୍ଜସିଟ୍ କପିଟା ସୁଦର୍ଶନ ବାବୁ କପିଟା ଟିକେ କହିଦେଲେ ସେ ଯୋଉ ଆମର ଚାର୍ଜସିଟ୍ କପିଟା ଏକ୍ଜିକ୍ୟୁଟ ଆଣ୍ଡ ଚାର୍ଜସିଟ୍ ଆଜ୍ଞା
ପେପର ବୁକ୍ ଟା ତ ନେଇଯିବେ
ପେପର ବୁକ୍ ରେ ନାହିଁ ସେଟା ମୁଁ ଦେଖିଥିଲି ନାଇଁ ଚାର୍ଜସିଟ୍ କପି ନାହିଁ ଆଣିଛି ରେଡିଓ ଥିଲା 12 ନମ୍ବର
item 12 by
लॉन्च पर आरंभ किया 10 मिनट
yes appellant 2 has already expired and 1 has available as per the
report has
already come by already come by he is alive he is alive and appellant number 2 has already expired dead already report has come by
by the order dated 14/8/2025.
Only one witness, my lord.
I
PW one, my lord.
oral time declaration is also there.
Oral. Well,
May I be permitted to make a mention? Serial number 16, the 5 ଜଣ appellant ଅଛନ୍ତି ତାଙ୍କ well-being ଟା ଖାଲି call for
କାହିଁକି ଆସିନାହିଁ 16 ରେ ଆସିନାହିଁ।
Well, 12.
Well,
Item number 12.
Yep, no appellant before your lordship. One appellant has already expired during the appeal period, my lord. Appellant convicted under section 302, 506 and 34 IPC. Each of the no imprisonment.
Why don't you read the first information report?
My lord.
So that we can have an idea about the case and
May. ମୁଁ ସୋମନାଥ ସବର ପିତା
ସୋମନାଥ ସବ ମାନେ କହିବେ PW.
my lord, PW1 he is the only eyewitness and a son of the deceased, my lord.
PW1 ତା ବାପା जी ଏ case ର
Deceased, my lord. Only one eyewitness.
ହଁ ପଢନ୍ତୁ।
ପିତା ମୃତ ତୁମ୍ବାଇ ସମ୍ବର ଗ୍ରାମ ତା ଡେଟ୍ 30/11/97 ତାରିଖ ଦିନ ରିପୋର୍ଟ ହେଇକି ଯେ 19/11/97 ବୁଧବାର ଦିନ ସନ୍ଧ୍ୟା ପ୍ରାୟ 5 ଘଣ୍ଟା ବେଳେ ମୋର ବାପା ଖଜୁରୀ କାଟିବା ସକାଶେ ଯାଇଥିଲେ। ମୁଁ ସେତେବେଳକୁ ପାଣି ଢାଳ ଧରି କଦଳୀ ବଗିଚାରେ ଝାଡ଼ା ବସିବାକୁ ଯାଉଥିଲି। ଏତିକି ବେଳେ ହଠାତ୍ ମୋର ବାପାଙ୍କର ପାଟି ଶୁଭିଲା। ରଡ଼ି ଛାଡ଼ି କାନ୍ଦି କରି ମରିଗଲି ବୋଲି କହି ମତେ ସାହାଯ୍ୟ କର। ଏହା ଶୁଣି ମୋର ବାପା ରଡ଼ି ଛାଡ଼ୁଥିବା ସ୍ଥାନକୁ ଧାଇଁଗଲି। ସେଠାକୁ ଯାଇ ଦେଖିଲି ମୋର ବାପାର ବେକକୁ ଆମ୍ବ ଗ୍ରାମର ସଲ୍ଲିଶବର ଓ ବିଷମ ଗ୍ରାମର ଲିମ୍ବୁ କାଣ୍ଡିଜି ଗୋଡ଼େଇ ହାଣୁଥିଲେ।
There are the two appellants.
There are two appellants.
अच्छा की ଗୋଟେ death is कार
Death is my lord Sillu Sabar has expired. ଗୋଡ଼େଇ ହାଣୁଥିଲେ ଓ ମୋତେ ସେମାନେ ଦେଖି ସେ 2 ଜଣ ମୋର ବାପାକୁ ସେଠାରେ ଛାଡ଼ି କିଏ ଯୁଆଡ଼େ ଧାଇଁ ପଳାଇଲେ। ମୋର ବାପା ବେକରେ ଆଘାତ ପାଇ ରକ୍ତାକ୍ତ ହୋଇ ଭାଲିଆ ଗଛ ମୂଳେ ପଡ଼ିଗଲେ। ମୁଁ ଅଳ୍ପ ଦୂର ଯାଇକି ମୋର ଦାଦା ଶାମ ଶବରକୁ ସେଠାକୁ ଡାକି ମୋର ବାପାକୁ ଧରି କରି ନେଲୁ। ବାପା ଘରେ ପହଞ୍ଚି ମାଆକୁ ଆମ୍ବ
ଏକ୍ସାମିନ ହେଇଛି।
PW5 ମେଲ। ବାପା ଘରେ ପହଞ୍ଚି ମାଆକୁ ଆମ୍ବ ପରିବାର ଲୋକକୁ କହିଲେ ଶଲ୍ୟ ଓ ଲିମ୍ବୁ ମୋତେ ବାଟରେ ହାଣିଦେଲେ। ଡାକ୍ତରଖାନା ପାଖରେ ନଥିବାରୁ ମୁଁ ନେଇପାରିଲି ନାହିଁ। ରାତ୍ର ପ୍ରାୟ 10 ଘଣ୍ଟା ସମୟରେ ବାପା ମରିଗଲେ ଓ ମୋର ବାପା ମରିବାର କିଛି ସମୟ ପରେ ଉକ୍ତ ଶଲ୍ୟ ଓ ଲିମ୍ବୁ ଆମ ଘରକୁ ଆସି ଧମକ ଦେଇ କହିଲେ ତୋର ବାପା ମର୍ଡର ବିଷୟରେ ଥାନାକୁ ରିପୋର୍ଟ ଦେବାକୁ ଯିବୁ ନାହିଁ। ତୁ ସକାଳ 6 ଘଣ୍ଟା ଭିତରେ ତୋର ବାପାର ମଡ଼କୁ ପୋଡ଼େଇ ଦେବୁ, ନଚେତ୍ ତତେ ମଧ୍ୟ ଜୀବନରେ ମାରିଦେବୁ। ଏଣୁ ମୁଁ ପ୍ରାଣ ଭୟରେ ମଡ଼ ପୋଡ଼େଇବାକୁ ସ୍ୱୀକାର କଲି ଏବଂ ଗାଁ ବାଲାକୁ ଡାକି ମଡ଼ ପୋଡ଼ିଦେଲି। ଏହି ଘଟଣା ପରେ ଉପରୋକ୍ତ ଆସାମୀମାନେ ମୋତେ ଥାନାକୁ କିମ୍ବା କେଉଁଆଡ଼େ ଯିବାକୁ ବାଟରେ ଜଗିଛନ୍ତି ବୋଲି ଶୁଣି ଡରରେ ଆସିନଥିଲି। ମୋର ବାପା ଶୁଦ୍ଧକ୍ରିୟା କାର୍ଯ୍ୟ କରି ବୋଲି ମାମୁଁ ପାଖକୁ ଯିବି କହି ଲୋରଡ଼ା ଗ୍ରାମକୁ ଯାଇ ମୋର ମାମୁଁ ସାରଥୀ ଶବରକୁ ସାଙ୍ଗରେ ସାରଥୀ ଶବର ମାଇଲର PW2 ସ୍କ୍ରାଇବର ଅଫ ଦ ଏଫଆଇଆର ସାଙ୍ଗରେ ଥାନାକୁ ଆସି ତାଙ୍କ ରିପୋର୍ଟ ଲେଖାଇ ଆପଣଙ୍କୁ ଦେଲି। ଆଜ୍ଞା, ତାଙ୍କ ଦ୍ୱାରା ରିପୋର୍ଟ ଲେଖାଇ ଆପଣଙ୍କୁ ଦେଲି। ମୋର ଏଇ ରିପୋର୍ଟ ତଦନ୍ତ ହେଉ ଥାଉ କି ମୋ ବାପାକୁ ପାଗୁଣିଆ ବୋଲି ସନ୍ଦେହ କରି ମାରିଛନ୍ତି।
କଣ ତା ମାନେ?
ब्लैक मैजिक बोली तो
That means there is no PM.
No, ma'am. No. This is as not examined, not medical examined by the
Obviously, the dead body was disposed of. They had
4 days.
IO had gone to the that cremation ground.
My lord, one of the witness said.
Yes, my lord. I visited the cremation ground and seized the some ashes
and bone.
Yes.
Was sent for DNA.
Not same day affair not lost.
It was
What was lost 4 days
4 days
after because you
he was under
PW10 is the doctor who examined the bone that
human.
See, one of the small bone. Opinion of my lord. May I read?
Opinion report issued by
the my lord, Director of Chemical Agent Government of Orissa, State SLFs Rasulgad Bonsar. That opinion of the result of the examination, opinion of the origin, age, X of the exhibit A, column not be given as one bond fully losing all its morphological and biological character.
Bond fully losing all the morphological and biological characteristics. So that report is there. এটা ঠিক পঠাই দেলে DNA
এই নাই।
আচ্ছা ଆଉ କିଏ ସାକ୍ଷୀ କହିଛନ୍ତି ମାନେ ନେଇକିନି ଗଲା ପୋଡ଼ିବା ପାଇଁ ଏମିତି?
No. In this case, the PW1 is the eyewitness, my lord.
Other witnesses?
Other witness PW4 oral dying declaration.
ଆଚ୍ଛା
ନାଇଁ who
Not in the
when the dead body was carried to the cremation ground and it was
ଏକୁଟିଆ ନେଇନଥିବ ନା
ସେ ପାର୍ଟରେ କିଛି କେହି ଏକ୍ସାମିନ ହେଇନାହାନ୍ତି। ତାପରେ PW3
ଯେ ପୋଡ଼ି ଦେବା ପାଇଁ ଏବଂ ଗ୍ରାମ ଲୋକଙ୍କର ସହାୟତା ନେଇକିନି
ସେ ପୋଡ଼ିଛନ୍ତି କିନ୍ତୁ ସେ ଏଭିଡେନ୍ସ କିଛି ଆସିନାହିଁ। କିନ୍ତୁ PW3 he has seen the injury on the body of the deceased. Soon after the occurrence, when the deceased was in the house, PW3 visited and found injury on the deceased.
Not in possible.
But in a murder case, the body is not required.
No, corpus delicti is a different aspect. Corpus delicti is a different aspect that will examine.
We just want to know that whether, because in such type of cases, you could have easily got the evidence that the villagers took the deceased, accompanied the dead body to the cremation ground, like that.
After death, police has not collected any evidence regarding cremation. But before death, police collected the evidence. They were examined and supported the prosecution case.
But PW6, another witness, the elder brother of the deceased, he has stated on the same day, police has come and a dead body has seen and collected some documents. Same day. Another witness, PW6, he is the elder brother of the deceased.
No.
FIR
Police says that it was, the police came to the spot only after the lodging of the
Lodging the
first
FIR,
information
yes.
report.
Stable.
So what other witnesses have stated that the police himself says we came
After,
on 23/11/1997.
Madam, witness, some of the witness said veracity, one of the witness said same day.
Have you suggested to the police that you did not come on 23/11/1997, but much prior to that? And
Before registration of the
before
FIR, you were there.
registration of the FIR in the village. ତେଣୁ ସିଏ ତ ନିଜେ କହୁଛି ମୁଁ 23/11 ଏତଲା ମତେ ଦେଲେ ସୋମନାଥ ସବର ମୁଁ ରେଜିଷ୍ଟର୍ଡ କଲି ରେଜିଷ୍ଟର୍ଡ କରିକିନି ଇନଭେଷ୍ଟିଗେସନ ଟୁକ୍ ଅପ୍ କଲି ତାପରେ ଆସିଲି ସ୍ପଟ୍ ଭିଜିଟ୍ କଲି ଇଏ କଣ ତାଠୁ ଗୋଟେ ଲାଇନ୍ ବାହାର କରିଦେଲେ। So now if whatever you submit or Mr. Nayak submits, that apart from this eyewitness PW1, with also the informant, there is also a witness like PW3 who had seen the deceased lying dead with
This is having injury
having injury.
on his
No,
person.
not only PW3,
PW5,
PW6, 7, everybody has seen it. They have seen the body and the caught injuries.
And one of them has stated about the dying declaration.
The oral diagram before PW4 and PW6.
Dying declaration.
Yes.
But in cross-examination, PW4, my lord.
6 तो किसी कोई नहीं.
PW4.
This is
Cross-examination.
It is told that accused persons killed him.
Yes.
In the cross-examination, he deposed
On
that
being
of
asked
his
what happened, my brother Dubai told that accused person killed him.
But my lord, PW4 in
PW4 house brother wife.
Wife.
wife, my lord.
My husband was alive
Yes.
at the time
तो
when
नहीं
he
गिरा
was
असली.
brought to my house.
Yes.
And my husband told that the accused persons assaulted him. There was caught injury on the neck of my husband,
Yes.
and in the night my husband expired.
My lord, in our cross-examination, he stated,
Whose procedure?
PW4, she stated that, my lord, para 2, he stated that line 1, 2, 3, 4 line, my lord. My husband was brought to our house at about 5 p.m. Samo, PW5, my lord. Dada, this is your my younger brother. And my son Somnath brought my house from the forest. I was present in the house when my husband was brought. My husband was kept in the house. The floor was stained with blood, and there was a cut injury on the neck of my husband. The head was not severed from the neck, but it was
bent.
And he could not tell anything more.
ଅଧିକ କିଛି କହିପାରିବ
He could not.
Yes,
The condition of the injured, my lord, he had not stated anything even.
No, anything else. He is not stating more. ଅଧିକ କିଛି କହିପାରିବ
He was not in a position to
state
state more.
Next para, Mumbai died in my house in the night. My husband died as soon as he was kept in the house.
କେତେ ଆଣିଲା ପରେ ସେ କହିଲା କଥା.
And delay was also properly explained. There is 20 kilometer distance from the place of from the and to cross has to cross a hill.
No, but the threat
Also
was
threat
there.
was there, no?
And
But PW1, my lord,
ଜଗିଲେ ବି ମଧ୍ୟ ଛାଡ଼ିଲେନି କୁଆଡ଼େ.
there are separate road, my lord. PW1 has in its cross-examination stated there was separate. Para 2, my lord. It takes 5 minutes to reach the bus stop of the Ranjipadar from our village. The said main road leads towards the Raigada on one side and the
bus stand
Hello.
ପାଖରେ ଅଛି ସବୁ ଠିକ ଅଛି ଯେ
Hey.
ଯୋଉ
he has
ତାର
not,
ଯୋଉ effect of threat, how it can go so soon when he has himself seen how the assault was made on his father by two persons and threat was given not to report and also to dispose of the dead body, all these things, and they were compelled to do so. They ତାର ଯଦି ସେମିତି ସାହସ ଥାନ୍ତା ତ ଫ୍ୟାମିଲି ମେମ୍ବର ସମସ୍ତେ ବା ଗାଁ ଲୋକ ମିଶିକିନି ଏକାଠି ହେଇକିନି କହିଥାନ୍ତେ ନାହିଁ ଚାଲ ଯିବା ଥାନାକୁ ଦବାକୁ. So it shows that there was
All have succumbed to the
all
pressure.
threat given. So
my lord, this
maybe
witness,
that
my
those persons might have some type of nature of criminal. Who knows that? Otherwise, the entire villagers seems to be. Some of the villagers came. They saw the injury on the so and so. Dying declaration was made. In spite of that, they were not reporting to the police, and the dead body was allowed to be disposed of. So
my lord, PW1 is my lord unreliable witness and the conduct of the witness is very doubtful. My lord, three things before your lordship. He had not saved the father's life in the when the occurrence happened, and another he has not shifted
He did
the
not save.
the father.
He did not save.
My
On
lord,
seeing him, accused
He
person
is
fled
the-
away.
fled away, and
His father was hacked by
No.
chase and fled
day-
away.
he had not examined the medical examined, my lord.
Who?
And PW1 is the son, my lord.
That medical examination.
No,
Assault
no,
is-
father, my lord.
That was
Five-
scope nahi. There was no
5 p.m. my lord. Occurrence happened 5 p.m. He has expired on 10 p.m. 5 p.m.
no.
She is in home, my lord.
So what was
Condition
the
is serious, my lord. Condition is serious, but he has not shifted any medical. And the same day he has not the third pattern, my lord, and the next day morning he has stated that next day morning.
ନା ନା
But
ନା ନା
the cross
threat ଟା ଆସିଲା
examination next day,
threat ଟା ଆସିଲା ରାତିରେ after death.
day morning, next morning, early morning. He has not informed the police and he has not shifted the medical, my lord. And when the my lord he left the home, he stated that my
ଏପରା
mother.
ଲେଖିଛି ସେ
my-
ଏଫଆଇଆର ରେ ଡାକ୍ତରଖାନା ପାଖରେ ନଥିବା ହେତୁ ନେଇ ପାରିଲୁ ନାହିଁ ରାତ୍ର ପ୍ରାୟ 10 ଘଣ୍ଟା ସମୟରେ ବାପା ମରିଗଲେ. When is this incident took place?
Occurrence
Inside the
my-
jungle.
No. In which year? 1997.
1997, my lord.
Which is this place? Was there any hospital nearby then?
Right.
How?
20 kilometers.
20 kilometers. What is the mode of
10
communication.
communication?
They have to cross a hill. It
Yeah.
is came in evidence.
He is the son, my lord. Father condition is very serious.
May it be.
Now,
What?
the conduct.
ଡାକ୍ତରଖାନାକୁ ଯିବାକୁ ପାଇଁ ଗୋଟେ ସ୍କୋପ ଦରକାର ନା.
IO stated that bus facility and a tractor facility, other facility are road communicator.
ସେ ରାତି 12ଟାରେ ଅଛି ଆଣିଛି ସ୍ପେସିଫିକ କ୍ୱେଶ୍ଚନ ଏଇଟା ଅଛି ଦିଟା ବସ୍ ଥିଲା. No, 5ଟାରୁ 10ଟା ଭିତରେ
ଆଜ୍ଞା।
ଏଇ ବସ୍ ଆଉ ଏଇ ବସ୍ ଚାଲୁଥିଲା ତମେ କିନ୍ତୁ ନେଲ ନାହିଁ. ବସ୍ ନେଇଥାନ୍ତେ କି କାର
Tractor ki any
do they
private
have their
taxi.
capacity to take for 20
ନଭେମ୍ବର ମାସ ଶୀତ ଦିନ ଅଲରେଡି ଆରମ୍ଭ ହେଇଯିବଣି. ସନ୍ଧ୍ୟା 4ଟା ବେଳେ ଘଟଣା ହଉଛି. ଘରେ ଆସି ପହଞ୍ଚିଲା ବେଳକୁ 5ଟା ପାଖାପାଖି ହେଇଯିବଣି. ସନ୍ଧ୍ୟା ହେଇଯାଇଥିବ ପାଖାପାଖି. ସେଇ କେସରେ ତାଙ୍କର ଯାହା ଦେଖୁଛନ୍ତି ଗୋଟେ ପାହାଡ କ୍ରସ କରି ସେପଟକୁ ଯିବାକୁ ପଡିବ 20 କିଲୋମିଟର ସେଠି.
But PW1 and 9 says another road is available. Another road available.
2025 also when somebody becoming pregnant and
Yes.
there is
They have been carried in a
they are carried
in a cot.
bahunga karikini
Remote area, my lord.
25 what you are telling about 97 in Rayagada.
PW1 and 9 stated in another road and another facility
ଠିକ
available.
ଅଛି ଯେ ରାତି ସନ୍ଧ୍ୟା ହେଇଗଲାଣି ଜଙ୍ଗଲ ଭିତରେ ଦେଇକିନି ପାହାଡ ଟପିକିନି ଯିବେ ଆଉ ଆପଣ କହୁଛନ୍ତି ଯେ ରେଡିମେଡ୍ ଯୋଉ କଟକ ଭିତରେ ଘଟଣା ହେଇଛି ଏସସି ମେଡିକାଲ ପୋଲିସକୁ ନେଇଯାଇଥାନ୍ତେ ସେଇ ଟାଇପର।
ସେ ମରିଯିବା ବିଷୟଟା ଜାଣିଲା ପରେ ଉଭୟ ଆସିଥିଲେ ତା ଘରକୁ ଏବଂ ତାକୁ କ୍ରିମେସନ କରିଦେବା ଲାଗି କହିଲେ। It is only after that in the very night that
PW1, neither anyone accepted in this thing.
No, PW1 corroborating evidence of the witnesses who came and saw the injured condition. There was injury on the neck and dying declaration. These are all there. It's not that only the evidence of the corroborating evidence.
The dying declaration can see the PW6. The elder
That's
brother.
3 kg, right? PW6 na 5 kg.
6 elder brother.
PW4.
Four wife, PW6 elder brother. I went, I saw my brother has already died.
No, PW5 na
4 and 6.
Dying declaration 4 and 6.
4 kg. My husband told me that accused persons assaulted him. There was spot injury on the neck of my husband in the same night. राति 10टा बेले मला 5टा बेलକୁ ଆସିକି ପହଞ୍ଚିଥିବେ ଘରେ। ସେ ତ କହୁଛି on that day 5ଟା ବେଳକୁ
Cross examination.
in the evening Somnath came and told accused persons so and so. So
another part, my lord, PW1, when the left, my lord, he had been to jungle to attend the lecture call. He stated that in her house only sister was present. My mother was not present, but mother has stated that in this time I was present. And another, yes, cross examination stated that Samo and Dada भी घरे ଥିଲେ, କିନ୍ତୁ दादा तांको एविडेंस कहते मु आम घरे ଥିଲି से हमको डाकी किने
एगुडा कोन गोटे
एटा स्टेटमेंट ऑफ PW1 न ये घरे ଥିଲେ ये नଥିଲେ
कोडी आइथिबो दे कोन करा it takes 5 minutes to reach the bus stop at so and so command village said road so and so towards Raigada one side on the
बस स्टॉप जे बस ଥିଲା ନା तापरे ए इंजर्ड को ए अवस्था कोन बस रे नहीं हो all these things are there.
Another part, my lord, weapon of offense has not seized by the woman. PW1 stated कथि द्वारा मरा होला that this thing is not seized by the IA. And the motive part has not, my lord.
Weapon of offense has not been
Produced, weapon has not seized, not seized by the IO.
Police seized Kati in which the accused persons killed my father.
And in his cross examination, it said that I will not seized by Kati.
किए कोई
PW9, my lord.
PW9.
9, sorry, 88, PW8. Initial 2 IO.
8 तक के
Initial IO, my lord. 2 IO in this case. Now, page 69 of the paper book and last line. I have not seized any weapon of offense.
कोठी से कहले को पैराग्राफ
Well, paper book
नहीं
page 69 no last line. Last row photo. I have not seized any weapon of offense. The cross examination the para or last row upper line.
Appellant's arrest के पहले
Hello, arrest on 24/11/1997. 23/11/97 FIR loss. 24/11/1997 both were arrested. In which place arrested not mentioned. I arrested the accused person on 24/11/97 on its same and forward to the court 25/11/97.
In this case, the weapon of offense was not seized. It is admitted. But seizure of weapon not a condition in the murder case, where there is direct eyewitness, oral dying declaration,
And,
other corroborative piece of evidence is.
PW1 and 4 stated relation were both the family were good.
They're close relatives, yes. Was there any circumstance brought in the cross-examination showing that there should be a murder by anybody else or under any other circumstance where you can say that the close relatives has the case implicating the petitioner, the appellant? So any circumstance has been brought into cross-examination?
My point is no enmity between the
Merely
deceased
because
and
a close
deceased and
relation is
accused.
not the ground.
Para prosecution para 20 to PW1 and PW4 and para para 7 million. PW2 is the scriber of the affair. His possession is stated that Korno is my own brother who is working as the police department. At the time, scribe the report. Police Babu was there. After the police Babu told me to scribe the report. And accordingly, I scribed the report.
What is that? ଯେତେବେଳେ ଥାନାକୁ ଯାଇକି ସେ କହିବାକୁ ଚେଷ୍ଟା କରୁ ସେ ରିପୋର୍ଟ ଲେଖିକି ଦେଲେ। ସେ କହିଲା ଆପଣ ଆଣିଲେ ଯେ ଥାନା ବାଲା ଯାହା କହିଲେ ସେଟା ସେ ଲେଖିଲା ବୋଲିକିରି।
Police Babu told me to scribe the
report ଦେ ରିପୋର୍ଟ ସେ ଦେଲେ।
ମୌଖିକ କହିଥିବ ଇଏ କହିଥିବ ଲେଖି ଯାହା କହୁଛ ଲେଖିକି ଦେ ତା ଇଏ ଆସିଥିଲା ତାକୁ ସେ କହିଲା ମତେ ଲେଖିକି ଦେ ବୋଲି ସେ ତାର ଲେଖିକି ଦେଲା ଆଉ କଣ।
ନାଇଁ ସେଇ ଯୋଉ my lord PW1 as also known as reading and writing. Scriber as stated there. Somnath is known to reading and writing.
ପଚାରିଲେନି ଯେ ଆପଣ ତ ପାଠ ପଢା ଶିଖିଥିଲେ ତାକୁ କାହିଁ କହିଲେ ଲେଖିବାକୁ ସେ ଏକ୍ସପ୍ଲେନ କରିଥାନ୍ତା ମୋ ମାନସିକ ଅବସ୍ଥା ଠିକ ନଥିଲା ମୁଁ ସେଇଥିପାଇଁ ତାକୁ ଇଏ କରୁଥିଲି ମୋ ଦେହ ହାତ ଥରୁଥିଲା କହିପାରିଥାନ୍ତା। Once you do not put any question, how do you expect that?
And another matter, this is your younger brother-in-law. He is working under police department. And another aspect, PW4. He stated that it is a para 11 my lord. It is a fact that when Korno was told we started the case. Korno is the police person and a younger brother-in-law of the deceased my lord. He is not a cited witness, but
unless specific question comes, if any answer comes from the mouth of the witness, who is admittedly a rustic witness, it is always said consistently that it is a battle between a rustic witness and a trained lawyer. So, you cannot expect that every answer that the witness gives being aware of this on the face of a friend.
Another aspect, prosecution has not do any motive and intention of the occupier.
But that is, eyewitness is there, motive is not.
No, somebody has said that he was killed because of on the ground that he was
Practicing
it is
reflected in the FIR.
FIR में last line Agunia Valley Sandhya very maritime.
PW1 ର paragraph 15 ରେ ମଧ୍ୟ କହୁଛନ୍ତି ଯେ I caught hold of one hand of my father, my dada caught hold of another hand of my father. We brought my father carrying him. It was evening time and there was slightly dark at the time when we brought my father. So this was the condition and it was winter season and you were expecting those persons to go to cross 20 kilometers and lost the FIR or when this state etc. were there and to dispose of the dead body and explanation paragraph 17 ने ମଧ୍ୟ ଦଉଛି last two lines. In the evening of the occurrence, we did not bring my father to the hospital since we had to cross hills
in the night.
And there is a road from so-and-so to our village. In the following day morning at about 6 a.m. we disposed of the dead body. When the accused person threatened me, I could not tell anything to my villagers.
The tribal people, they used to live separately.
I was not seized by not at the time I returned both PW1 and PW5. The help of deceased, blood stain and other parts are not seized by them. It will let you cross PW9. I have not seized any blood stain from the house of the deceased.
PW8 blood stain seized kala. PW8. I also seized blood stain earth, sample earth, one gudakudava, branches of a tree stained with blood at the spot, and prepared figure list. Exhibit 4.
PW9 stated that I have not seized any.
PW subsequent I. He recorded the 164 statement of some witnesses and sent the bone pieces to SFSL and submitted charge.
Dying declaration PW1 भी कहुची chief examination there page 49 में 1 2 3 4 5 6 7 lines. On arriving in the house, my father told my mother man PW4
And
other family members that both the accused persons killed him in the same night. So version of PW1
1, 4, 6.
coupled with 4. One witness has not supported the prosecution case, he says. 6 has not supported.
3 and 7 is the independent also, he has not supported it.
It's all right, but
3 and 7.
the PW1 has
PW
stated about
also
this,
I
which
don't
is
know.
also
3 and
stated
7.
by PW4. Three and 7.
3 and 7.
No, by the time he reached he says in cross-examination that I saw he was lying dead. So where is the question of making dying declaration? He came afterwards.
Yes.
Right.
तीन number टा कहूनी cross-examination रे. When I went, I saw Dumbai was lying dead. ତେଣୁ ଆପଣ ଭାବୁଛନ୍ତି କି ଯେତିକ ଲୋକ ଆସିଛନ୍ତି ସମସ୍ତେ କହିବେ dying declaration ବିଷୟରେ?
No.
ସେତେବେଳକୁ ପୁରା ମରିଗଲାଣି ସିଏ.
PW3 only see injury on the neck.
ହଁ ଇଞ୍ଜୁରି ଥିଲା ଠିକ ଅଛି କିନ୍ତୁ ସେତେବେଳେ ସେ ଅଲରେଡି ମରିଯାଇଛି. ଆଉ ଗୋଟେ କାହାକୁ କହୁଛନ୍ତି?
PW7 by
7.
He has also seen the injury on the neck.
I do not know nothing. No, on the following day morning, I went to the house.
In chief, he stated that after hearing the occurrence, I went to the house of Dumbai Sabar and saw cut injury on his neck. In cross, stated that on following day morning, I went to house of Dumbai Sabar and saw Dumbai was laying dead.
So one is evidence of the eyewitness PW1. Number 2, dying declaration evidence
PW4.
stated by PW1 and PW4. Then explanation given as to why they could not shift the deceased who was in an injured condition to the hospital because it was already evening has already there, darkness has prevailed, and it was a 20-kilometer distance, and they have to cross a hill. And next, about the delay in lodging a fire, explanation has been given about the threat.
And trial court also accepted that.
And that has stated. And you say that about this motive. Of course, in the FIR it is stated. Any other witnesses stated about it?
No.
But as Mr. Naik is pointing out, when the eyewitness person is there, then
in circumstantial evidence, motive is a
the prosecution has proved the motive or not, it becomes immaterial. If you could not get over the evidence of this eyewitness, then merely because you say that no motive has been proved, that may not be.
No, so if
बाकी अपन जहाँ corroborating evidence मिली था ता eyewitness रा version को, the dead body was disposed of because of the threat. As so, obviously that is not there.
Dead part may not except PW1, neither anybody except.
Nobody was there at the spot. He had gone to attend the call of nature. He heard his father's voice and rushed to that place. And found
से ऐसी कौन घरक आसी जो कहले
after late in the night after the death.
সেই টাইম রে
ଦି ଜଣ କହିଲେଣି ନା ମା କହୁଛି ପୁଅ କହୁଛି PW1 ଦି ଜଣ କହୁଛନ୍ତି ବାପା ଏଇଆ ଆସିଲା ପରେ ଏଇଆ କହିଲା ଯେ ଆକ୍ୟୁଜ ପର୍ସନ ମାନେ ମତେ ମାରିଛନ୍ତି ବୋଲି ଆଉ କିଏ କହିବ
ଥ୍ରେଡ
ଆଉ
ପାର୍ଟ
ଯୋଉ ଲୋକ ଆପଣ କହୁଛନ୍ତି କେତେ ଜଣ ତା ଦେହରେ ମରିଗଲା ପରେ ଆସିଛନ୍ତି ତାପରେ ସେ ତ ଗୋଟେ ଥର ହୁଏତ କହିଥିବ
ଆଉ ଥରେ
ଯିଏ
କହିବା ଅବସ୍ଥାରେ
ଆଉ
ଅଛି
ଥରେ
କି ନାହିଁ?
ଅଛି କି ନାହିଁ କେମିତି ଆପଣ
thread part your lordship except PW1
PW1 is the
He is the
witness to
person
the
in the
occurrence.
time of affair in the home as the son. So he has been asked not to go. He has been asked to do certain thing, and he did it. Had he not been done, then you could have said that yes, he did not succumb to the threat, and he did this, he did that. But here he has acted.
ବର୍ତ୍ତମାନ ତାର ମନରେ ଏ କଥା ବି ହୁଏତ ଥାଇପାରେ ଯେ ମୁଁ
ନକଲେ
ଯଦି
ମତେ
ନ
ମାରିବେ।
କଲେ
ମତେ
ମତେ ମାରିଦେବେ ବା ଫ୍ୟାମିଲି ଲୋକମାନେ
କାହାକୁ
ଅଛନ୍ତି
ମାରିବେ?
ଏଇ ଜିନିଷ ମୁଣ୍ଡରେ ଷ୍ଟ୍ରାଇକ୍ କରୁଥିବ ତେଣୁ ସେଥିପାଇଁ ଡିସ୍ପୋଜ ଅଫ ଜଣେ
Only male person in the family.
ଆଁ?
PW1 is the only male person in the family.
younger son ଅଛି
Huh?
ଆଉ ଗୋଟେ younger son ଅଛି decision
Here see,
ଆଉ ଗୋଟେ younger son ଅଛି stated that PW4 ଝିଅ ଏ ସମକୁ
ମାନେ ସେ କହୁଛି I have one sister ବୋଲି କହୁଛି PW1
ଝିଅ ତ
ପାରାଗ୍ରାଫ ନମ୍ବର 5 ରେ ମୋର ଗୋଟେ ଭଉଣୀ ଅଛି ବୋଲି ତା ନାଁ ହଉଛି ସୁନିତା ବୋଲି ସେ କହୁଛି
a cross examination para 9 Sunita is my daughter PW4 PW4 Sunita is my daughter and my younger son were not examined by the police another male person was available younger son
what was his age?
hello
What was his age? Have you put?
age
Younger son was of what age?
PW1 has also stated in paragraph number 7 that after seeing the assault made by the accused persons on my father, I came to the house of Shyam Sagar. Shyam Sagar is PW5.
PW5 menu
ହେଲା ଏବଂ PW ଏବଂ ତା ହେଲ୍ପରେ ମୁଁ ବାପାକୁ ଆଣିଲି PW5 ମଧ୍ୟ corroborate କରୁଛି ଯେ ମତେ ଇଏ ଆସିଲା ଡାକିଲା ତାପରେ ମୁଁ ଗଲି ଏବଂ ଆମେ ତାକୁ ନେଇକିନା ଆସିଲୁ
କିଏ କହୁଛି ସେ ଆମ ଘରେ ଥିଲା ଇଏ କହୁଛି ମୁଁ ଆମ ଘରେ ଥିଲି
But that is not true. My nephew Somnath came to me and told me to the occurrence, and when told to accompany, I went along with him to forest and brought Dumai to his house. There was injury on the right side neck of Dumai. Dumbai was alive when he was brought to home. Ye kintu kohine kintu say he has seen him, he was alive. Yes.
ଏବଂ ସେ paragraph 4 ରେ କହୁଛି ମଧ୍ୟ I brought Dumbai from the place of occurrence and left him in his house and went away.
and that is also 1 hour distance from the place of occurrence to the house.
Hmm.
No, but the evidence is that by the time they reached home, it was already evening.
Yes.
Darkness has prevailed because it was a winter season, and the distance is that much. That is why on that day, why they did not carry the body to the
Hospital.
injured to the hospital. The reason has been given that this is the state of affair. बाकी गोटे आनिचंदी कोन बस स्टैंड टा and it was pointed out that bus service सेतबेले से शीत दिन राति रे सेतबेले बस दिला
बस चलतला कम्युनिकेशन कोन था
And even if the family member did not carry the injured to hospital, that does not wipe out the offense of the accused person.
No, that's a different matter. No, he said that they could have carried, but this is the position in which that somebody, obviously they would have tried if it would have been a reachable distance. I mean to say at that point of time, that place, it depends so many factors. Night is there. There is chance of wild animals also attacking. You have to cross a hill. That is the evidence. 20
And
kilometers.
after carrying the injured to hospital, what would be his health condition? Whether that is possible to.
Obviously, it's not an ambulance that they have to carry it by some mode, and it's a night time.
No, existence of the bus stop in a close proximity does not give you any immunity, saying that yes, they have not taken proper step.
If on paragraph 4, your village is surrounded by forest. And specific explanation why it is not.
Schedule 5 in proceeding para 4, he has stated that when the occurrence happened, this place was situated para 4 melon. Somnath has also come. I have not quoted the PS. The data trees were situated in one side and the plantation garden is situated on the other side. Nothing is visible from the banana garden when the nature of
he heard the scream. He has not seen.
Visible.
He heard the scream. ସେ କଣ କହିଛି ମୁଁ ତ ଶୁଣିଲି ମରିଗଲି ଶୁଣିକି he heard the scream, the outcry.
Next line, nothing can be heard from the garden. Nothing be seen and nothing be garden. P5. P5 की शाम
तो आई विटनेस नो
नहीं से संगरे जो डेड बॉडी जो नहीं कर सकते
ये कह दिले कौन
वन रू कौन आंचंती what are the findings of the learning trial court?
Yes.
You please total denial.
Yes, complete denial.
Complete denial.
Both of you. You are on bail or you are outside or inside?
On bail.
On bail.
On 22/9/2001.
My lord, paragraph 16.
Let us show the finding of the learning trial court. Paragraph
16 to
page 16 रे हाँ नहीं finding उड़ा देता हूँ ये तो YCC है या कल से आई और evidence quote कर ले तापर ये 9 टा quote कर ले 10 टा quote कर ले अच्छा
हमें careful
19
हाँ इटा paragraph 10 रे आसिला finding टा you injury noticed by 156 on the neck of the injured and others want so, hence the above indicate no suspicion in any manner the death of the deceased has been caused being assaulted by the accused person by means of kati. जो eyewitness को और अन्य मानव को तारा evidence को नहीं तापरे a one रो evidence discussion. dying declaration टा मतलब से paragraph रो believe correctly why so stated by so coupled with the direct evidence will be disbelieved. Proper dying declaration
My lord. In this case, my lord, the eyewitness account is corroborated by the PW5, who on the invitation of PW1 accompanied PW1 and carried the injured to house. Thereafter, the evidence of PW4, before whom the deceased stated that the accused person are the author of the crime. PW1 is also witness to that oral lying declaration. And other witness, my lord, PW victim should be found and identified. That is, conviction of the offense of murder does not necessarily depend upon corpus delicit being found.
Corpus delicti.
Delicti being found.
One thing you have to say, admittedly, it was not an instantaneous death.
Yes.
All right.
Yes.
And maybe because of some hindrance, but the deceased could not be taken for treatment. And the actual incident, the injury, and the time of death is almost 5 hours. So, how could you say that this is a 302?
Yes, my lord. The intention of the accused person was to kill. Only because of the hindrance of the PW1, they could not succeed
Correct.
to eliminate the.
But probably he could have been survived.
Yes.
If timely intervention, medical intervention would have been there, he could have survived.
Yes.
So why not part 1? Why not part 2? Why 302? कौन ता उपरे कौन करछन ना सीधा 302 नहले नाही आउ
प्रिपरेशन
अछि कोन
299 रो गोटे अछि देखछन्दी 299 आईपीसी रे explanation 2 टा देखो
My lord. Where death is caused by bodily injury, the person who caused such bodily injury shall be deemed to have caused death, although by restoring to proper remedies and skillful treatment, the death might have been prevented.
एवढा केते जगह रे हेई पारे माने एवढा को देख एथि पई नै छन्दी
yes
जे रूरल एरिया रे थिबो
yes
हमें ता कहिथबो एविडेंस आनिबो जे हमें ता जे नै एई था तो एम्स को
हेई थांता
पहुंची था हम सबको ये था किंतु लोकेशन को जगह रे होची फैसिलिटी अवेलेबल अछि ना नहीं Yes,
My lord, in this case, the ocular evidence is the accused person have assaulted on the neck of the
Neck. Vital
deceased.
part of the body, that is
That
there.
is a
no, that is there. But my esteemed brother point out. But one thing you see, the FIR story, if you read, that number of blows were given.
Yes.
That is not there here. ଏଇ ଯୋଉ ଆସିଲେ ଏତେ ଲାଗୁ ମାନେ
ଗୋଡାଇ ଗୋଡାଇ ହାଣୁଥିଲେ।
ହାଣୁଥିଲେ।
ସେଠାକୁ ଯାଇ ଦେଖିଲି ମୋ ବାପାର ବେକକୁ ସ୍ପେସିଫିକାଲି
ସେତିକି ବେଳେ ମୋ ବାପାର ପରିବାର ଏହା ଶୁଣି ବାପା ରଡି ଛାଡୁଥିଲା ଭାଙ୍ଗିଲେ ସେଠାକୁ ଯାଇ ଦେଖିଲି ବାପାର ବେକକୁ ଆମ ଗାଁର ସୁଆଂଶୁ ଗୋଡେଇ ଗୋଡେଇ ହାଣୁଥିଲେ। Obviously, ଦି ଜଣ ପାର୍ଟିସିପେଟ କରିଛନ୍ତି ବୋଲି ଇଏ ହଉଛି ବଟ୍ ଇଞ୍ଜୁରି ଯାହା ସମସ୍ତେ କହୁଛନ୍ତି ଗୋଟିଏ ମାତ୍ର ଇଞ୍ଜୁରି ଥିଲା ନେକ୍ସରେ।
ଗୋଟିଏ କଥା କହୁନାହାନ୍ତି, we found injury on the neck.
ତାମାନେ ଗୋଟିଏ ଇଞ୍ଜୁରି ଆଉ କଣ ଆଉ କୋଉଠି ଇଞ୍ଜୁରି ବୋଲି କିଏ କହୁଛି କି? କାରଣ ପୋଷ୍ଟମର୍ଟମ ତ ହେଇନି। ଆପଣଙ୍କର ଘର ଲୋକ ଯୋଉମାନେ ରହିଛନ୍ତି ତା ସ୍ତ୍ରୀଠୁ ଆରମ୍ଭ କରି କି ଅନ୍ୟମାନେ କେହି ଆଉ ଅନ୍ୟଟି କହିଛନ୍ତି କି ଆଉ କୋଉଠି ମୁଣ୍ଡରେ କି ଅନ୍ୟ
ହାତରେ ଆଉ ପଞ୍ଜାରେ ହବାର ତ ଆଉ କିଛି
only on neck.
Except 37, all are the family members.
ତେଣୁ ଆପଣଙ୍କର there was admittedly there is no evidence of any enmity between these parties. So what actually happened at this spot? Why this person's assaulted and gave that blow to the neck? That is nothing is there. And if the medical evidence is also not there to say that it was sufficient in ordinary course of nature to cause death, it may be that due to this passage of time, excessive blood was there. So that may be also one of the reason for which the death has occurred. Hello? So maybe that body part select ହେଇଛି ମାରିଛନ୍ତି। So ହେଇପାରେ 304 part 1 ବି ହେଇପାରେ। But unless you bring it ଏଇ ଯୋଉ ଗୁଡାକ 302 ର ଆପଣ ଆଣିବାକୁ ହେଲେ ଯେ sufficient in ordinary course of nature, intention to ଏଗୁଡାକ ଯୋଉ ଦରକାର 299 ରେ ତାର ବ୍ୟାକଗ୍ରାଉଣ୍ଡ ର ଆପଣ କିଛି ଏଭିଡେନ୍ସ ନାହିଁ ଓ ତାର ପ୍ରିଭିୟସ୍ ଏନିମିଟି ବି କିଛି ନାହିଁ କାରଣ I think the PW1 himself has stated that
PW1 and 4 both are PW1 and 4
one ର ସେ ଲାଇନ ଟା କଣ PW1 ର ସେ ଯୋଉ
apprehending that he was
20
practicing black magic, he was
ସେଟା ହଉଛି FIR
proceedings para 20 ରେ ଅଛି
20 ରେ କାହାର PW1 ର
PW1 we are in good terms with the accused person prior to the
wait PW1
para 20 ରେ ଅଛି
କୋଉ ଲାଇନ ଟା କହିଲେ
ମାନେ para 20 ର ଲାଇନ ହେଲା 1 2 3 4 5 ମାନେ 6 ଲାଇନ we were in good terms with the accused person prior to the occurrence
ଆଉ କିଏ କହିଛି
and para PW4 ମାନେ
Sarathi has got good relationship with the accused person.
Sarathi is another man, he is elder brother.
We were in good terms. We were in good terms with the accused person prior to the occurrence.
Sarathi is the
PW4
proceedings
Sarathi is PW7
ମାନେ
No, it is PW1, family of PW. We were.
The accused persons had no bad relationship with my husband. Okay, it out.
para 7 ମାନେ
କେତେ ବର୍ଷ ରହିକି ବେଲ୍ ହେଇଥିଲେ ଜାଣିଛନ୍ତି କିଛି ଆଇଡିଆ ମାନେ ବେଲ୍ କେବେ ହେଲା
ବେଲ୍ ହେଇଛି ସେପ୍ଟେମ୍ବର 2000
2000 ରେ ବେଲ୍ ହେଇଛି
ଆଜ୍ଞା 22 2020
ଫାଇନାଲ ଫର୍ମ ଟା
ଅଛି 88 ଅଛି
କଷ୍ଟଡି କି ଗଲା 97 25/11/97 25/11/1997
22/2000 ହାଇକୋର୍ଟରେ ବେଲ୍ ହେଇଛନ୍ତି।
3 ବର୍ଷ ମାତ୍ର ଥିଲେ।
22/2000
पार्ट 1 में कॉपी जीवे और
जीवे
ये 10 से कम नहीं।
Lord, that happened, my lord, being the state council, my duty to assist your lordship. My lord, if one injury is there, two accused person, one accused person already died, then beyond all reasonable, it cannot be pointed out to the present.
No, the way they have one died,
both-
it's all right. Died means does not that absolve him. The conviction
34 is there, no?
The conviction is still there. He has died, it's because that has abated. It does not mean that he has been acquitted. So 34 is still there, but obviously it has abated.
He has not been acquitted, no?
No.
He is abated.
And the what is it? And say trial court bail ନଥିଲା and that was on the date of admission of
ସେଇଟା ତ
5/6/2006 ପରେ admission ହେଲା 3 ମାସ ପରେ 2019
20 ନା
6/6/2000 admit 6/6/2000
2009/2000
admit भी single judge ପାଖରେ ହେଇଥିଲା।
ବେଲ୍ କିନ୍ତୁ ଗ୍ରାଣ୍ଟେଡ୍
ଭ୍ୟାକେସନ ରେ ଥିଲା ଭ୍ୟାକେସନ ରେ ହଉଛି ଭ୍ୟାକେସନ ରେ ମାନେ ବେଲ୍ ବି କନସିଡର ହେଇପାରିବ there is nothing
Bail भी single
admission should have been in the division bench but bail can
could
be
have been.
considered
single judge ମଧ୍ୟ bail
at that point of time that was
no sorry
डिवीजन
division
बेंच
bench, sorry.
बेलटा डिवीजन बेंच
Chief
bail
Justice
division benches ଦେଇଛି ନା କହିଲେ ବି admission should not have been
ଭ୍ୟାକେସନ ଯୋଉ ହେଇଛି
we are not entering into that
In this regard, I prefer small. And some decision there then today, and I'm not there as well. But written not some.
got any idea about the appellant what he is now doing what is this
This is a legal aid matter last. Criminal of you also direction.
A report is there. Lingaraj Karji is alive, staying with his family members.
Appointed to legal aid. As per you. नहीं इधर पेंडिंग रे एचआर पेंडिंग रे मैडम
The appellant is alive
the last
and staying with his family members in village Bishnu.
last orders.
ना ना बिस्मा रायगढ़ ना गजपति
21/8/2025. No, order dated 21/8/2025. Order dated 21/8/2025. You have appointed. नहीं appointed.
Postal director. I'll call you. ଭିତରକୁ they were not on bail during trial. They only 22/2000
नहीं नहीं फिर 9
Matter came to High Court and they did it without the bail.
କୋଡ଼ିଏ ନଅ ରେ ବେଲ୍ ଲାଗେ। 3 ବର୍ଷ ବି ହଉନି। ଦୁଇ ବର୍ଷ 10 ମାସ ରହିଛନ୍ତି।
Next Tuesday. You bring since it's a jail criminal appeal.
No, criminal appeal.
No, criminal appeal, but nobody is now responding. He has been engaged as the
amicus
curiae. Because that financial condition may not be strong. Otherwise, and it is private law. The Kali Mahapato was there earlier.
Yes.
Since that's
फाइल इज विथ ମୁଁ କଥା ହଉଥିଲି ଫାଇଲଟା ତାଙ୍କ ପାଖରେ ନାହିଁ ନଥିଲା।
इसी डिनाई कला पर
financial condition of criminal antecedent. Let me do hard Malaya Kumar Swine, Land Counsel for the appellant. Appellant number 1, Lingu alias Lingaraj Karji alias Buya. And Partha Sarathi Nayak, an additional government advocate. The Land Council for the petition appellant takes a citation which is taken on record along with the written note of submission. Written note of submission and citations which are taken on record.
The citation I have not read.
It is key.
ମୁଁ ଦେଲି।
only repeat
এটা purpose দেলি
আচ্ছা
দিয়েছি মেমো অফ দিয়ে দিই
I will file on Tuesday.
আচ্ছা দিও কিছু অসুবিধা আচ্ছা এটা করে মেমো করে দিও the land council for the state files a citation with a memo করে দিও which are taken on record. it appears that the petitioner was taken into judicial custody in connection with this case on 25/11/1997, and he was not released on bail during trial. However, during pendency of the appeal, he was granted bail by the order dated 20/9/2000. Let the Land Council for the the Land Council for the state had earlier produced the written instructions from IIC Rayagada Police Station, District Gajapati, dated 12/8/2025, that the appellant is staying with his family members in village Ishma. Did the Land Council for the state obtain instruction regarding his financial condition, health condition, and also if there is any other criminal antecedent against him. The date is this case further target on 16th of September 2025. The report shall be produced in the meantime. So hardly passport in the so you are a matter of coverage. Say vision, so data who prune as you. Upon rocket number, out your 20 ready.